Hey, what's up, everyone? Normal America show. I don't know how much time I have today. There's some ironies going on today, which maybe you all will appreciate as well. So I do have to go into work here later, but I just had some thoughts about the debate I had the other night as I was sitting here thinking this morning about things. Wanted to go on stream and sort of talk about this. Now, I'm open to talking to Pisco again about this particular issue, though I don't know if he'll be interested in doing so. But that's sort of what I'll be talking about here today. So, what I want to do is sort of say things that I think Pisco was right about and that I now concede that I'm wrong or that I had a misunderstanding. Thank you, Corey Barton, for $2. Says Big Soda would be proud of you. Thank you. I actually haven't been drinking soda much lately, so they might not be too proud. I've been almost strictly water, and I have some diet green teas. Boy, there's a fat old man beverage if I've ever heard of one. Diet green tea. But so now the jurisdiction thing's boring, and ultimately it doesn't matter. But I'm going to explain to you why it matters to me. Two reasons primarily. But first, let's talk about why it doesn't matter. Regardless of how the debate with me and Pisco went, he basically makes the concession that's most important as to why I brought up the idea of clearly Boasberg lacking jurisdiction in the first place, which was there's a fundamental belief that I think is absolutely correct, which Pisco basically concedes to, that there was forum shopping, that what's going on is there are a bunch of Democrats and other people that don't want any of these people deported. And so what they're doing is trying to find the one court that they think will most likely halt the Trump administration's ability to do anything. And Pisco concedes that. Yes, that's what's going on. And as you'll get to some of the cases I'm about to read here, the courts have a massive problem with that. They think when it comes particularly to the habeas statutes, that would be a massive problem, because what happens is it means that you're basically allowed to write down anyone as the defendant and then forum shop to any district that has subject matter jurisdiction. So it'd be some 90 something districts, federal districts in the United States, and then take your case to the one that you think would be most likely to operate. Now, imagine that every single litigant does that, and then the Supreme Court would have to weigh in every single time. So it's clear that the Supreme Court was saying, like, we're trying to avoid that. And that's why the language is very specific. And as you'll see, apparently in like 1867 or something, when they Congress re-updated the habeas writ statute, that was their concern, that they added the part about that basically it had to be in their respective jurisdictions of confinement. The reason was to sort of avoid this whole thing. So then the debate really becomes about whether or not using the term jurisdiction was correct. Now, when I used the term jurisdiction, what I meant was it wasn't in the proper area for him to decide. Not subject matter area, but like geographic area. That the dudes that were being deported weren't from D.C. and they weren't being held in D.C. and they weren't picked up in D.C. And so therefore it wasn't up to a D.C. judge to decide whether or not these guys should be shipped out. Now, I understand that it's going to be different, and I fully concede that I'm a layman. And so my initial understanding of things is going to be oftentimes, even if gut feeling correct, not correct in the specific legal sense, which is one of the reasons that I like talking to people in the law field. Oftentimes, I think that I am usually correct, even if I don't have the terminology, etc. But I'll admit when I'm incorrect, and I think there are times that I can admit that with this debate the other night. But so the idea for me would be like, imagine if, let's say there was some form of, like, let's say Trump protesters, right, do something crazy in California. They have like a January 6th thing in California, right? And so the California judges lock them up and they file a writ of habeas, and then a state that's super pro-Trump, right, like Alabama, has a district judge there that's like, yeah, I'm granting this habeas. So California can't lock these people up. That would seem to be problematic, right? That's the exact feeling that I had here, that these people are being deported And a judge that doesn't want these people deported is going to weigh in when he's not the appropriate judge for doing so. That's what I use the term jurisdiction for. Upon further reflection, the term jurisdiction is far more complicated than I initially believed. However, the important part is that I was correct in the sense that he wasn't in the correct geographic location. And more importantly, all of that aside, he did not have the authority to issue the temporary restraining order to tell these planes to come back and to bring back these people. He did not have that authority. Now, all of this further debate, you could tune out. You could tune out because everything that I'm going to be talking about today and the debate I had with Pisco, all of that is acknowledged, what I've just said. Supreme Court ruled this judge didn't have the authority. The question before us is, was it that he didn't have the authority because he lacked jurisdiction? Or was it merely because he lacked proper venue? That's it. That's the entire debate. To me, the debate is meaningless from the ground of what the implications are for us as a country, what the implications are for us as sort of debating these issues, the morality of it, etc. Now, the only way that these implications would even matter, even in a legal sense, would be if somehow the distinction between lacking jurisdiction and lacking authority based on venue meant that we had some sort of different rulings that were likely to come up because of that. But the problem is, as we'll get to, even if we accept the territorial jurisdiction rules of the habeas law as merely venue, they still operate under the scope like other sort of jurisdictional rules. It's sort of different than just general venue concerns that may be reasons to appeal. But from a process sense, whether it be because of improper venue or because of lack of territorial jurisdiction or any other type of jurisdiction, Boasberg couldn't rule. He did not have the power. That's it. Now, if that's it and the debate doesn't matter, we both are agreeing. We agree that it was forum shopping by Democrats. We agree that the Supreme Court weighed in that Boasberg didn't have the authority to rule. It's just a basic semantic question of, was that authority because he lacked jurisdiction or because he lacked venue? That's it. Now, to Steelman Pisco's position, Pisco will say, but there were those claiming that Boasberg lacked subject matter jurisdiction, i.e. no federal circuit judge would be allowed to weigh in regardless of the territory, regardless of the venue. But I'm not making that argument. Old Joe, congratulations, man, on winning custody. It has to be one of the greatest feelings in the world. There is nothing more important than being a parent. So congratulations to you. Canisius, 4W for $5 says, if the courts become overly political, would break the third branch. It may be broken already. Dems and reps both have claimed that within the past year. Yeah, certainly true. So that's it. The issue doesn't matter from the scope of... Now, Pisco will say, well, Rob, I don't agree with you that he blatantly didn't have jurisdiction. And that's fine. We could have a disagreement on that. But we agree on this, that it was forum shopping, that the Supreme Court said they're worried about habeas forum shopping, and that the Supreme Court ruled that Boasberg lacked the authority to issue the TRO. That's 99% of everything that should concern everyone when it comes to that discussion. So then why am I interested in it? Because I love meta arguments. So the two reasons in particular that I'm interested is, the less important reason is because Pisco appeals to his sort of career and sort of this appeal to authority as an attorney. If he is technically wrong on this legal matter, it's sort of embarrassing. That's one. And the second reason is because I absolutely love learning. And for me, the best way to learn about something is to debate about it. I've always been the type of person that learns or gets better at things through sort of competition. And so for me, I have this like inner monologue that runs in my head all the time, but it becomes much more focused and sharp if I'm talking to someone else about it, whether that be through a debate, whether it be through a discussion, whether it be through like an official game activity, like college debate that was literally a game where you're trying to win. That's always when I learn best. And for people that have been following me a lot recently, you know that because of my laziness, first and foremost, but also because I've been very busy, I don't have a lot of time before I do debates to research anymore. Now, I did some research before this debate with Pisco, but what I've been wanting is to get into debate where either I didn't know something or someone challenged me in a way that made me think, wait a minute, I now have to look into this. And so I'm happy for that to have occurred. Now, do I think Pisco won the debate? No. I think that perceptually, probably from hour 2 to about 3.5, he looked much better than me. There's 2 reasons for that. One, even if I'm directionally correct, anytime I'm talking with a lawyer, an economist, a doctor, oftentimes the jargon and I don't mean jargon to imply necessarily a negative connotation. The specific nomenclature or specific area that we're talking about can sometimes confuse when I'm trying to think like of what the main purpose is of what we're talking about. So, for example, a good mechanic, if he starts getting good, you take out the word good, a mechanic that is very skilled at using the technical language of his job might be able to convince you of all sorts of problems of your car, even if you know before you go in there, look, it's a problem with the taillights. Or maybe they could convince you you need to pay $1,000 to fix that when you know, like, no, I know it's only like $50. When I had a discussion with a convoy at one point, we were talking about inflation, and I was saying, look, the government massively printed money. That causes inflation. And he was like, no, 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 it's the velocity of the money. Well, there was a term I'd never heard. But when I later researched, like velocity of money was basically when you create the money, if you just create it and put it in the Federal Reserve and it doesn't go anywhere, then the velocity of the money that's been put out is basically zero. So you have to create it and then put it into circulation. Well, that was implied in what I was saying with creation of money. And yet, when it's a term you don't hear, you're like, so I will admit that from like hour 2 to like 3.5, there are points plus, not to make other excuses. This isn't really an excuse anyways, but I don't know why. I just got like tired and sort of bored of it becomes it gets thrown on and on and on where to get like 2 feet into a debate, it takes you like an hour. Well, actually, Rob, hat could be shoe was an argument that he was making. Riverbank, like a type of a bank. Well, what about a riverbank? Is that a type of a bank? Yes, river would be the descriptive of bank. Well, what if we said there was fish jurisdiction? Okay, then that would be fish would be the descriptive word of the word jurisdiction. And it just gets nonsensical. Imagine that before you had any debate, imagine that your wife or your husband or whatever, man or woman, says to you, what do you want for dinner tonight? Well, in fact, I'll give you a quote that I like. Carl Sagan had this quote. It said, if you want to create an apple pie from scratch, you would first have to create the universe. Think about that for a second. I made this apple pie from scratch. Really? You made the apple tree? You did that? That's sort of what this is like. Well, define every term. Imagine if we did this. Like, imagine if I said, Pisco, what's your definition of jurisdiction? And he said, a court's power to decide, this was his definition, a court's power to decide a case or issue a decree. And I said, okay, define A. The first word in that is A. Next, define court. Next, define power. Next, define to. And then each definition. Well, couldn't it theoretically, the definition of A could mean something different, right? What if I use the definition of A to mean something differently? Imagine how that debate would go. Imagine how arduous it gets. That's what Pisco is doing. And so it becomes, you get bogged down in that. So I think I would give myself a B- or a C+. I don't think it was my best showing. But having said that, as I started to think about this debate, I think there are points that Pisco's convinced me of things on. And I initially started to think that maybe I was wrong and that the court's, my opinion was that the court actually didn't say that Boasberg didn't have jurisdiction. That's until I did some more heavy reading. And so I want to start by talking about things that I think Pisco was right with. Sometimes because of the way Pisco argues, he makes things overly complicated, which might seem to help him in a debate, but I don't think it does. I guess it depends on what your purpose is in the debate. If your purpose is to obfuscate and just run out the time, because you'll notice that we spent like roughly 3 hours or so on Pisco's premises and conclusion. And I had two arguments with premises and conclusion. We spent about 15 to 20 minutes on. Now, in fairness, some of what we were talking about, my premise and conclusion, were included, but that was the direction of the debate. Him getting to argue his case and me trying to poke holes in it, as opposed to the opposite. So one of the things is, when we were talking about the term territorial jurisdiction, I have to give Pisco credit for this. To me, when someone says, does the court have territorial jurisdiction, that meant, does it have jurisdiction based on territory? However, I understand, it took me a while to understand this, what the other term could be. Now, the difficulty is both of these, I'm very bad at grammar, but I believe both of these are nouns. Having jurisdiction would be having a thing. A jurisdiction is also a thing. A jurisdiction is a location. Having jurisdiction is having an ability to rule. And that's what Pisco was trying to explain to me. And because of the way he was going about it, and because maybe I'm an idiot, I wasn't getting it. So, for example, when he defines territorial jurisdiction as, and I'll share screen, I'll show some of this. From Black's Law, 1, jurisdiction over cases arising or involving persons residing within a defined territory. So territory in this definition, point 1, is the location. So I drew a map, crudely, of Pennsylvania. That's the territory. Territorial jurisdiction in this definition would be the court that has jurisdiction here. The second definition that you see highlighted there is territory over which a government or one of its courts or one of its subdivisions has jurisdiction. So in definition 1, the territorial jurisdiction is the courts that have the ability to rule here. In definition 2, this is the territorial jurisdiction. So jurisdiction means both a location and the ability to rule. So his claim is, and I will be fully honest, and I'm not going to make any excuses. Yes, I think in part because the way he went about it, I was confused, but like, not confused necessarily, bored. and I guess confused about the like, well, what about a fish bank? What about a? But certainly, I think a lot of it is my ignorance on legal matters. And regardless of what you all think of Pisco, it's one of the reasons that I like talking to him because I learn things. And it's one of the reasons I like talking to anyone. Like, I like talking to Destiny. I like talking to a lot of people that disagree with me. Once it just becomes trolling and shit, then of course there's no benefit. But so his argument would be akin to this. So just because a place lacks, we would say that there is a territorial jurisdiction that could hear these cases. That doesn't necessarily mean the right to rule, jurisdiction, the authority to rule or issue a decree. It may just mean the geographic location. Now, the problem is it gets very confusing, but that geographic location is defined by a location of which people in that district have the right to rule, to issue decree. And so there still becomes significant problems in the idea of, if we say this court lacks territorial jurisdiction, of saying, no, they don't lack jurisdiction, though. Because when we say it lacks territorial jurisdiction, what we mean is it lacks the geographic area. It lacks this, the state. It doesn't have this. It has jurisdiction to rule, but it doesn't have the territorial jurisdiction, i.e., it doesn't have the location to rule. Oh, yeah, sure, average debate enjoyer. Hit me up, man. The other issue that I think is worth giving some concessions. Yeah, Mr. Ubercross says it's fuzzier when dealing with federal and state jurisdictions. It's sort of a bundle of sticks. The other issue where I think is also very fuzzy, and I don't concede 100%, but I will concede that I'm leaning towards Pisco's side on this, but I want to hear someone argue the other side of this, is the claim that venue is if you lack venue, that you don't lack jurisdiction. Now, my understanding going into this was, again, let's use this map. Here's Pennsylvania again. This isn't the case in Pennsylvania, but just to simplify it, right? We have District 1 and District 2. Okay, we'll just assume for the sake of argument, Pennsylvania, territorial district, the government of Pennsylvania, its Congress writes laws which the courts are allowed to rule over. So the territorial jurisdiction is the geographic location of Pennsylvania. The courts of Pennsylvania do not have the authority to rule on matters outside the state of Pennsylvania. They are their own sovereign states. It can only rule within the boundaries of its own territorial jurisdiction, barring exceptions. So, if a court has improper venue, so I commit a crime in venue 1 here, but the court is venue 2, does the court in venue 2 have jurisdiction even though it's the improper venue? I would say yes. It has jurisdiction, i.e., the Congress, unless specifically written otherwise, which is going to be very important, probably just says theft charges in Pennsylvania within the geographic territorial district jurisdiction of Pennsylvania. Criminal courts in Pennsylvania may adjudicate these certain crimes. Okay. So that's what's at issue here. So the state of Pennsylvania's criminal courts have jurisdiction. However, it could have improper venue. And so when Pisco's like, well, listen, just because it has, or if it's just a venue issue, it's not a jurisdictional issue. And I'm like explaining, like, no. I keep saying this. I'm like, you could have a territorial jurisdiction, right? And have venue issues. But if you don't have territorial jurisdiction, it's never the proper venue. In other words, here's the territorial jurisdiction. So then something happens over here in Ohio. No, you don't have territorial jurisdiction. You also don't have proper venue. But we're here. Yes, there's territorial jurisdiction, but no, it's improper venue. In other words, if the court, this court, does not have territorial jurisdiction, then it is never the proper venue. If it happens here, if it happens here, if it happens here, then no, this venue cannot be proper. Not venue 1 or venue 2. If it happens in Pennsylvania, venue 2 may be improper, but it would still have territorial jurisdiction. Does that make sense to everyone? In my head, that was the easiest way to make it out. So therefore, I'm correct. But not really. I'm actually incorrect. And here's how I think, to me, it made sense. I hope I'm doing justice to maybe what Pisco would say here. He says, but wouldn't that make every venue issue a territorial jurisdiction? If you say sometimes you could have improper venue, but still have jurisdiction, territorial jurisdiction, wouldn't that mean that every territorial jurisdiction issue is sort of a venue issue? I think that he needed to be clear about regarding the United States. So for me, if that makes sense in the state level, which it does to me, and I hope it makes sense to you, then why wouldn't it make sense here? Here's my crudely drawn United States map. Let's say there were only 3 federal court jurisdictions in the United States for sake of argument. 1, 2, 3. I commit a crime here in 3, a federal crime, but the venue is here in the West Coast. It's an improper venue, but did they have territorial jurisdiction? Their jurisdiction gives them, their territorial jurisdiction is crimes within just like here. This is a sovereign territorial jurisdiction. This is a sovereign territorial jurisdiction. If you could have improper venue within a territorial jurisdiction, why wouldn't that be the same here? In other words, just because Judge Boasberg's here in jurisdiction 3, we'll call it, and the people confined were in jurisdiction 2, he still has jurisdiction. It's just a venue issue. Because he could still theoretically, if they were here or if they waived their rights, he could adjudicate the matter. That to me, I think, and maybe I'm wrong, maybe that's not an easier explanation, but to me, the understanding how there's multiple venues in a state, you could apply it to that. Now, there's going to be a problem. So that's where I was today. Then here's the other issue. We're going to read a lot here coming up. Oh, of course, the first thing I want to read, I didn't pull up. Go figure. Let's see if I can find it. Are you kidding me? Oh, there it is. Okay. No. His issue is he's claiming that it's a venue issue. It's only a venue issue. If that's true, that it's just venue, And he is right that if it's only venue, then it's not jurisdictional. And I've conceded that there can be times where it could be a venue issue, but that there still was jurisdiction, like in the state of Pennsylvania. Then Pisco would be right. Now, one of the problems I have with this is I'm not so sure that this would be accurate, though, because I'm not so sure that these are all venues that we would say that the same way that this is sovereign. I don't know that that's the case federally, because federally, the truth is these might not be venues. These are districts with distinct jurisdictions. You see what I mean? So, for example, I'm not so sure that the Pennsylvania court says, or the Pennsylvania Code of Laws says, courts can only try crimes that occurred in their own venue. I don't think it'll say that. It'll say the best place is probably the venue, but that's just a layman's idea of how I think Pisco may be right. Libertarian Hippie for $20 says most state constitutions apply to the citizens even when outside of the state, but aren't enforced. Jurisdiction precedes venue. Venue is determined by superseding jurisdiction based on many facts. All factors are jurisdictions. Yes, that's sort of what I'm going to get here. There are many things that require jurisdiction. You could lack jurisdiction for lack of personal jurisdiction, lack for subject matter jurisdiction, lack of some types of territorial jurisdiction, etc. You must have all of those in order to have the power to rule, to adjudicate, to issue decree. That's what I'm getting at as well. So I think the first place to start, now we'll give one more thing where I think it goes to Pisco's side of the argument, and then I'll push back. So what I want to do is read for you all. It's not very long. This will be the shortest thing that we're reading pretty much. The actual Supreme Court decision. And we're going to read the whole thing, including the concurrence with Kavanaugh. So here's what they decided. This matter concerns the detention and removal of Venezuelan nationals believed to be members of the Tren de Aragua. Did I get it right that time? An entity of the State Department has designated a foreign terrorist organization. The president proclaimed, invoking the Alien Enemy Act to detain and remove Venezuelan nationals who are members of TDA. Invocation of the Alien Enemy Act regarding the invasion of the United States by Tren de Aragua. 5 detainees are a putative class sought injunction and declaratory relief against the implementation of and the removal under the proclamation. Initially, the detainees sought relief in habeas, among other causes of action, but they dismissed their habeas claims. On March 15, 2025, the District Court for the District of Columbia issued two temporary restraining orders preventing any removal of the named plaintiffs and preventing removal under the AEA of a provisionally certified class consisting of all non-citizens in U.S. custody who are subject to the proclamation. On March 28th, the District Court extended the TROs for up to an additional 14 days. The D.C. Circuit denied the government's emergency motion to stay the orders. The government then applied to this court seeking the vacatur of the orders. We construe the TROs to be appealable injunctions. Real quick, one thing I want to say, I know I said I was going to give Pisco's argument first, but I think there's a separate issue here that was not brought up, which is because he issued that stay on behalf of the entire class of people, and actually the ruling says, no, you can't do that. Only individual judges in the course of responding to a writ of habeas could do that, may show that it's outside of his jurisdiction, i.e., you can't make a ruling for people that you know won't all be within your jurisdiction. That's sort of a separate issue. And so it may be correct to say that they said he didn't have jurisdiction because his claim's not just these 5 people, it's all people. Now, the court said that absolutely everyone that would be deported under the Alien Enemy Act has the right to due process, which in this case, the remedy would be a writ of habeas. But only individual specific judges will be able to see that. To make a proclamation on everyone that would be in that class of people, I don't know. That might be outside his jurisdictional scope. Yeah, it's sort of a class action. So would that be sort of, I think arguably that would be outside of the scope, that they would say he does not have jurisdiction to rule on a class action. Nonetheless, I didn't make that argument, so we'll table it. Let's see, where were we? District Court, two temporary, yes. The DC Circuit denied the government's emergency motion to stay the orders. The government then applied to this court seeking vacatur of the orders. We construe the TROs as appealable injunctions. We grant the application and vacate the TROs. In other words, we're vacating the temporary restraining order. They side for the Trump side. The detainees seek equitable relief against the implementation of the proclamation against the removal under the AEA. They challenge the government's interpretation of the act and assert they do not fall within the category of removable alien enemies. But we do not reach these arguments, so we're not deciding whether or not they're actually removable under the AEA. Challenges to the removal, which largely precludes judicial review, must be brought, holding that habeas was only cause of action to the challenge during deportation, available to challenge deportation under that precluded judicial intervention beyond what was necessary to vindicate due process rights. Regardless of whether the detainees formally requested release from confinement, because their claims for relief necessarily imply the validity of their confinement under the AEA, their claims fall within the core of writ of habeas corpus and thus must be brought in habeas. An immediate physical release is not the only remedy under the federal writ of habeas. See this case that explains that a prisoner may seek to overturn his death sentence in habeas by analogy. For core habeas petitions, this is the line that I was focused on. For core habeas petitions, jurisdiction lies only in one district, the district of confinement. That's Rumsfeld v. Padilla. Now, to me, that's a simple, when I say, like, it's simple, thanks so much. Take Credible Hulk for becoming a member. If there's only one jurisdiction, every other jurisdiction, in this case, Boasberg, would be outside of that, not have jurisdiction. This is where Pisco is saying, though, no. It's not saying jurisdiction, the ability to rule. It's saying jurisdiction, the geographic location. So in other words, let's take out the word jurisdiction. The geographic location that has the ability to rule would only be one district. And that is the district of confinement. Now, there's still problems with that because I don't think that he ever shows a definition of the term jurisdiction that wouldn't mean jurisdiction. Or let me rephrase that. He doesn't show a definition of the term jurisdiction that doesn't mean the court's ability to rule. His specific definition was, let's see. A court's power to decide a case or issue a decree. But what he would say is, well, it would be just like territorial jurisdiction. I'm talking about the geographic location. I think that it's an easy victory because it's clear to me that what the court is saying here is the only place that's allowed to adjudicate this matter is only in the district of confinement. Now, where Pisco's, where I think he does make some inroads is, he's saying, but that's just venue. That's the only reason they say that. It's because of venue. So they don't really mean jurisdiction. They mean venue. So that was a quote from Rumsfeld v. Padilla. Now let's go further. It says the detainees are confined to Texas, so venue is improper in the District of Columbia. Grab a drink. See, it says venue. So then we get back to Pisco's argument, which is if habeas territorial jurisdiction rule is just venue, then it's not jurisdictional. And it is venue. And he says, see, This says it's venue. So this is admitting that jurisdiction's venue. I don't think it is. I don't think that they're saying, and by the way, I then get Pisco to change his argument. He has to argue if the habeas territorial jurisdiction is only a venue rule, then it is not a jurisdictional rule. And habeas territorial jurisdiction rules are only venue rules. Now, I think that this proves that they are venue rules, but are they only venue rules? We shall see. But he's saying, see, when they quote the Padilla court that says jurisdiction lies only in one district, the district of confinement, they're taking that to mean just venue. So this is the improper venue. As a result, the government's likely to win on this. We'll skip this part. For all the rhetoric of the dissidents, today's order in per curiam confirmed that the detainees subject to removal orders under the AEA are entitled to notice an opportunity to challenge their removal. The only question is which court will resolve the challenge. For the reasons set forth, we hold that venue lies in the district of confinement. The dissents would have the court delay resolving the issue, requiring, given our decision today, when the process begin anew down. We see no benefit in wasteful decision. See, they're saying venue only. Kavanaugh, then, with his concurrence. I agree with the court's per curiam. Importantly, the court stresses the court's disagreement with the dissenters is not over whether the detainees receive judicial review of their transfers. All 9 members of the CRE agree that the judicial review is available. In other words, we all agree that there's subject matter jurisdiction to review people being removed under the Alien Enemy Act. That venue question turns on whether those transfer claims belong in habeas proceedings or they may be brought under the Administrative Procedures Act. I agree with the court that they must be brought in habeas. So he agreed, or he seems to also say venue. That's it. That's the core argument then. Pisco has to argue, one, and remember, he admitted that he has to add the word only in here. Premise 1, if habeas territorial jurisdiction rule is only a venue rule, then it is not a jurisdictional rule. Premise 2, habeas territorial jurisdiction rule is only a venue rule. So when you read the court saying jurisdictions only in the area of confinement, he's saying, but that means the habeas territorial jurisdiction rule. So when they say jurisdictions in the area of confinement, read it. Here. For core habeas petitions, jurisdiction lies only in one district, the district of confinement. Pisco would have you read it. For core habeas petitions, the habeas jurisdiction rule lies in only one district, the district of confinement. In other words, what he's saying is this jurisdiction rule in habeas isn't actually at all a jurisdiction rule. It is a venue rule. And so just because, imagine that, if you call a cat a dog, and you say, all dogs get beef for dinner tonight, you would say, yeah, but not that dog because it's a cat. Yeah, but you're calling it a dog. Yeah, but it's not really a dog. By dog, we mean cat. Now, I disagree, and it was an argument that I'm making, albeit sloppily. I don't think they would say jurisdiction if they didn't mean jurisdiction. I think that instead what's going on is Pisco is taking a bunch of judges and scholars that are writing about things independently that aren't focused on this one issue of habeas and saying what it means to them, the difference between venue and jurisdiction. And oftentimes they're conflating terms, as almost everyone admits, and I've since learned, that jurisdiction is sort of a chameleon of a word, that it could have a ton of different meanings. You could have jurisdiction, for example, the one case that they cite is about this guy who was declaring bankruptcy, and this other dude was like, hey, I think it's Morvey Olson. Or no, that's not the correct. But in this case, this other dude's like, hey, you missed the timetable on a lot of what you procedurally had to do in order to file this bankruptcy. And so he's seeking to have the case dismissed because it's like the court no longer has jurisdictions because the law says that things must be done in a certain timetable. But the question is, are there exemptions or exceptions to when the court would be able to rule against that? And in that case, they're saying, well, subject matter jurisdiction is like unique in the sense that it's unwaivable. For example, I can't, if me and Andrew Schnatter there in chat, if we have a civil dispute, like the type of case you would see on like Judge Judy, I say, hey, he bumped my car in the parking lot and it put a dent in my car and it was $500. He owes me that money, right? We can't both mutually agree, you know what? We're going to have this criminal court in Texas that doesn't deal with civil matters. We agree. They got some free time over lunch. We agree to have them hear the case. They can't do that because they don't have subject matter jurisdiction. And it doesn't matter that we say, we're okay with that. It's like, no, you can't do that. However, you could do that with matters of personal jurisdiction. You could do it with matters of venue, with arguably matters of territorial jurisdiction. And so the authors of Pisco citing is like, look, because these forms of these forms of things like venue are waivable. You could waive venue. I could have a business in Pennsylvania and get sued in Ohio and say, that's okay. I waive my right to venue. I agree to allow this court to decide on the merits of the case as long as the Ohio court has subject matter jurisdiction. Now, the problem, which becomes even more confusing, is sometimes venue could be a matter of, yeah, I guess Ubercross, you're right. Maybe the better way to say would be, I commit a crime and we agree to allow a civil court to hear it. You can't do that. The civil court will never have the authority to hear my criminal complaint. Parody of language says, the problem is a lawyer and a layman having a debate about law. Expertise matters in this sort of thing. Maybe, but sometimes if you wanted to be, or if you were wrong, your expertise could make you seem right, even if you're wrong. Brody Delfino, for $5, says, what do you think about the suspension of habeas? It's constitutional, but just incredibly heavy-handed. That would kill all of these arguments. Yeah. I would not agree with the suspension of habeas, as I've argued before. I think that if you're going to accuse people of being enemy terrorists, they should have the right to defend themselves in some form. I don't think that we should suspend that. And maybe Mr. Ubercross has different feelings on what I'm going to say going forward, why I think Pisco is uniquely wrong. But he then goes on to cite a bunch of things that say why venue can never be a jurisdictional rule. Now, remember, he has to, in order to win, he has to rule if habeas is only a jurisdiction rule, habeas territorial jurisdiction. And if habeas territorial jurisdiction rule is only a venue rule. And he even says it here. Supreme Court has stressed the important distinction between jurisdiction and venue in the Nearbu case and other cases. This has been repeated time and time again in case after case. Venue rule can never be jurisdictional rule. But that's not true. That's not true at all. just because venue isn't necessarily jurisdiction doesn't mean that it never is. Libertarian hippie. Thanks so much for another $10. Says Pisco's argument was trying to separate the concept of jurisdiction from specific type of jurisdictions, then say venue has no association with either when they're all intertwined. It's so dumb. Right. And that was my argument from the get-go. Even in the initial discussion we had, when I say this judge didn't have jurisdiction, Pisco goes, yes, he had subject matter jurisdiction. Right. That is a particular type of jurisdiction that is necessary in order to have jurisdiction, which is a court's power to decide a case or issue a decree. You would need to have multiple things in order to have the power to decide a case or issue a decree. If you don't have the power to decide a case or issue a decree, then you don't have jurisdiction. So for me, my two arguments were, let me pull this up. I got this somewhere. Here we go. My arguments were: first, jurisdiction is the court's power to decide a case and issue a decree. Second, the Supreme Court ruled Boasberg did not have the power to decide this case or issue the decree. Therefore, the Supreme Court ruled Boasberg did not have jurisdiction. Second, premise one, for core habeas petitions, jurisdiction lies only in one district, the District of Confinement. Second, the Supreme Court ruled the remedy for plaintiffs would only be habeas petitions. Third, Boasberg's jurisdiction is not the area of confinement. Conclusion. Therefore, the Supreme Court ruled that Boasberg did not have jurisdiction. So let's deal with these one by one. Both of these, by the way, would supersede Pisco's, right? Pisco's definition is, or argument is, if habeas territorial jurisdiction is only a venue rule, then it's not a jurisdictional rule. And habeas territorial jurisdiction rule is only a venue rule. That would be superseded by the fact that my arguments assume his and have concluded. So there must be a flaw in his argument. Right? If he says, no, I assure you, habeas jurisdictional rules aren't jurisdiction rules, and the Supreme Court says jurisdiction, there's only one court with jurisdiction, this court, then he's wrong. The court has issued that he is wrong. Him saying, no, those words don't mean what they say is irrelevant. If jurisdiction is the power to decide a case or issue a decree, and the Supreme Court ruled that this decree was not able to be issued, then they ruled that he didn't have jurisdiction. Those were the arguments that I went in with. Now, to the first, the argument I just gave there, I think there are times when an appellate court, or in this case, the Supreme Court, could rule that the lower court didn't have the power to issue a particular decree that you may argue doesn't mean that they're not jurisdictional. That's going to be the most, very shrewd of you. That's actually going to be the most important part of all of this as we go on. Andrew's going to nail it there. So you may say, well, there's an argument to be had, and I'm going to say I will be willing to dispense with that argument. So I'm going to spend the rest of the time solely focusing on the following argument. One, for core habeas petitions, jurisdiction lies on only one district, the District of Confinement. Can I win that? I have to win all of my premises to win the debate, right? So let's see if I'm able to prove that. Is it true that for core habeas petitions, jurisdiction lies in only one district, the District of Confinement? Is that what the court ruled? It says, for core habeas petitions, jurisdiction lies in only one district, the District of Confinement. I win premise one. I don't think even Pisco would attempt to disagree with that. In fact, I took premise one directly from this quote. I win that premise. Premise two, the Supreme Court ruled the remedy for the plaintiffs would only be habeas petitions. Okay, let's see what the court ruled. For all the rhetoric of dissents, today's order in procurum confirmed that detainees have subject removal orders under the AA and are entitled to notice and opportunity to challenge their removal. The only question is which court. For these reasons, we vacate. Sorry, wrong section I wanted to read. We grant the application, vacate the TROs. The detainees seek equitable relief against the implementation of proclamation under the AEA. Their challenge to the government's interpretation of the act and the assert fault do not fall within the category of removable alien enemies. We do not reach these. Challenge to removal under AEA, a statute which largely precludes judicial review, must be brought in habeas. Holding that habeas was the only cause of action available to deportation under immigration status that precluded judicial intervention beyond what was necessary to vindicate due process rights. Regardless of whether detainees formally request release from the confinement because of the reliefs necessarily imply the ability of their confinement or removal under the AA, their claims fall within the core of writ of habeas corpus and therefore must be brought in habeas. Do I win premise two? Yes. Is it true that the court ruled the remedy for the plaintiffs would only be habeas? Yes, they did. Veda, thanks so much. As Pisco was quick with the definition of power came up. If you're going to use Black's Law jurisdiction, then you must use it for power. Yes, we'll talk about that at the end as well. Totally agree. Does anyone disagree? Even if you're a lefty that despise me, or if you could just put a hat on and try to steal man Pisco's position, right? Let me try something. This works. So we're looking here at section 2. For core habeas petitions, jurisdiction lies only in one district, the district of confinement. I was able to prove that, right? Easy. That's what the court ruled. Second, the Supreme Court ruled the remedy was habeas. Yes. Now, this is where the argument would be had then. Boasberg's jurisdiction is not the area of confinement. We know that's true. Therefore, the Supreme Court ruled Boasberg didn't have jurisdiction. Seems to be simple. Now, Pisco's argument is going to be that the word jurisdiction, as quoted here, does not mean jurisdiction. It means habeas territorial jurisdiction, which actually means venue. So what this sentence should say is venue lies only in one district, the district of confinement. That's the debate. So Pisco has to argue that it is only a venue rule to win. He has to win that habeas jurisdiction Does everyone agree? That's the debate. So you just saw my premise there. He has to argue when it says jurisdiction lies only in one district, that actually that means venue is only in one district. And he has to win, in order to win his definition, or his argument, he has to win habeas territorial jurisdiction is only a venue rule, then it's not a jurisdictional rule. And habeas territorial jurisdiction rule is only a venue rule. That's it. Now, there is a separate question of whether or not venue rules can be jurisdictional rules. The jurisdiction of federal courts, their power to adjudicate, is a grant of authority to them by Congress and thus beyond the scope of litigants to confer. And that's interesting. Remember that line. So this is what Congress has said. And so therefore, we can't disagree about it. But the locality of the lawsuit and the place where the judicial authority may be exercised though defined by legislation relates to the convenience of the litigants as such, they're subject to their disposition. This basic difference between the court's power and the litigant's convenience is historic to federal courts. Section 51 merely accords the defendant the personal privilege of respecting the venue or the place of the suit, which he may assert or may waive at his election. So what this is saying is, see, jurisdiction is different than venue because venue is waivable. Next source. I disagree. Venue and jurisdiction are quite different concepts. Jurisdiction is a court's power to hear a case. A proper venue is a place where the lawsuit is deemed convenient. Just because a defendant has conceded that the court has power over him, it does not mean that the court would be a convenient venue for a particular case. And when a defendant consents to a court's jurisdiction only impliedly because of automatic state law, he said nothing about the court's convenience. So his consent to jurisdiction had nothing to do with the rights under the venue laws. The defendants consented to the court's jurisdiction only implicitly. This does not mean they consented to district as a venue. Next. Jurisdiction determines the instant remand issue, not venue. In fact, the venue of this action is the same location one as the plaintiff's where he filed for the lawsuit, Miami-Dade. Thus, the critical question is whether this court has jurisdiction over the action. Indeed, the cases cited by the plaintiff clearly indicate the difference between an issue of jurisdiction and an issue of venue. The Doe court specifically held that there is a distinction between venue and jurisdiction. Venue is one thing, jurisdiction is another. They are not synonymous. Venue concerns the privilege of being held accountable to a court in a particular location. Jurisdiction is the power to act, the authority to adjudicate the subject matter. Lastly, venue is distinct from jurisdiction. Venue may be proper or improper, independent of questions of subject matter or personal jurisdiction. It is my argument that all of these people citing the distinction between jurisdiction and venue are actually citing the difference between subject matter jurisdiction and venue. Oh, who's rating? In other words, it's using the term, and it'll be admitted all over the place. You'll see when we read some more documents here. When judges are using the term jurisdiction, they mean all kinds of crazy shit. So in other words, what these people are saying is, and you can see it in that last post there, where it specifically says, venues improper or proper, independent of subject matter or personal jurisdiction. And this previous one, when you hear it talking about venues one thing, jurisdiction's another, they're not synonymous. It comes with the privileges of being held to the court in particular location. Jurisdiction's the power to act, the authority to adjudicate subject matter. Now, if the word subject matter wasn't there, there's more of a case that they're talking specifically about the term jurisdiction itself. But there is a specific type of jurisdiction that is necessary to have complete jurisdiction. That would be subject matter jurisdiction. So it is entirely reasonable, and no one in this court or in the court that he's going to cite the case with Kennedy in the concurrence, the Padilla case, no one argues that there isn't allowed for subject matter jurisdiction in these cases. Federal circuit judges have the right to weigh in on habeas claims. They have that subject matter jurisdiction. The question is, do they have the other types of jurisdiction that are necessary? Pisco will say venue isn't a type of jurisdiction that's necessary. Territorial jurisdiction is not necessarily a type of jurisdiction that's necessary. But what I want you to ask here is, all four of these, all four of them, remember what, let's say we grant them all. Do you see any of these that says venue rule can never be a jurisdictional rule? Any? What I just read to you, did you see anywhere that it says if it's a venue rule, it can't be a jurisdictional rule? No. It just says they're not the same thing. This is where I was getting to when I kept saying, if you lack territorial jurisdiction, you are always the improper venue. So if I'm in appeals court and I say, your venue is improper, I could also say, and furthermore, your territorial jurisdiction was improper. Both would be true. It is the improper venue, and you don't have jurisdiction based on your geographic location. Or perhaps you don't have personal jurisdiction. The venue is improper because you don't have personal jurisdiction. So I could say, no, it's the wrong venue. In other words, if it can be the incorrect venue because it lacks a type of jurisdiction, then his claim that venue rules could never be jurisdictional rules is incorrect. Now, I know people are going to say, is this just me being semantic? It's not. And we'll get to this in a second. So far, we're on premise one of Pisco's arguments here. If habeas territorial jurisdiction rule is only a venue rule, then it is not a jurisdictional rule. Second, habeas territorial jurisdiction rule is only a venue rule. He has not proven that it's only a venue rule. He just asserts venue rule can never be a jurisdictional rule. In all caps, nowhere does it say that. Now, I said this earlier. The entire debate hinges, or early in the debate, his entire premise, too, he only has one source for. Habeas territorial jurisdiction rule is not only a venue rule. He only has one source, and that is Justice Kennedy's concurrence in this Rumsfeld v. Padilla case. But Brody, he can cite that. It's easy to cite a case where venue was improper, but the court had jurisdiction to oversee the case. That happens all the time. Show me one case where a place lacked jurisdiction where it was considered the proper venue. That's the question. So you'll see here when we go to, so now Pisco's going to go on to premise two. The habeas territorial jurisdiction rule is a venue rule because the Supreme Court said so. SCOTUS also said so much in Rumsfeld v. Padilla. Judge Boasberg held the same. Here's what he cites here. One, he cites the same thing we already read from the decision. This is Kennedy's concurrence. We're going to read this whole thing. Don't worry. And the only other thing he cites is Boasberg's own words. We'll read what Boasberg says. Relevant to the defendant's court's class-wide TRO was not jurisdictional. At worst, the Supreme Court held it was a venue was improper because the District of Columbia. Indeed, regardless of how the issue is framed, the court has been clear that any reference to habeas jurisdiction does not refer to the court's subject matter jurisdiction. Correct. No one's claiming that. Again, Boasberg is conflating the term jurisdiction with subject matter jurisdiction. Rather, the territorial jurisdiction rule is a question of proper venue. He says, where's he get that from? Kennedy. And it's black letter law that while subject matter jurisdiction goes to whether any federal court may even hear the dispute, venue determines which jurisdiction possessing the court is most convenient. Just like the availability of cause under the APA, that question has been determined by statute, the federal habeas statute. But again, notice, he's not using the term jurisdiction. He's conflating the term jurisdictional with subject matter jurisdiction. Now, the fact that there exist more than one type of sort of sub-jurisdictions, there's personal jurisdiction, territorial jurisdiction, subject matter jurisdiction, implies that subject matter jurisdiction is not the only jurisdiction. Right? Otherwise, why you wouldn't call if the only type of ball that existed were footballs, or let's use a better football's fine. You would just call football balls. You wouldn't have to be descriptive of the type of ball because that's the only ball. And near everyone agrees in my reading, and I'm a layman, but even when I asked Pisco, he was unable to provide me any legal scholars that suggest that subject matter jurisdiction is the only type of jurisdiction. In fact, if I go to Cornell Law School, they define jurisdiction very similarly to black law. I don't have access to black law, by the way. The power of a court to adjudicate cases and issue orders, almost the exact definition in black law. It says, one of the most fundamental questions of law is whether a given court has jurisdiction to preside over a given case. A jurisdictional question may be broken down into three components. One, whether there is personal jurisdiction. In other words, whether the court may even hear the case involving the particular defendants. That's broken down into three types of personal jurisdiction. Second, whether there is subject matter jurisdiction, and whether there is jurisdiction to render the particular judgment sought. In other words, one may have subject matter jurisdiction, but if you lack personal jurisdiction or the jurisdiction to render the judgment sought, then you don't have jurisdiction. You don't have the power to adjudicate the case. Libertarian hippie for $50. Thank you. It says, Rob, you give me hours of entertainment and oodles of info. It's really sad no leftists are smart enough to make a legitimate argument. They all lie and squirm like slippery fish. We need you to keep debating. Expose the BS. God bless. Thank you. I appreciate it. So when you see Boasberg say, again, we'll show this. Boasberg's like, well, it's not jurisdictional. The TRO is not jurisdictional. It was venue. Any references to habeas jurisdiction does not confer subject matter jurisdiction. Notice he doesn't say does not confer jurisdiction. He says subject matter jurisdiction. Yes, no one disagrees. Oh, I wasn't showing that. See? Up top, the first highlighted sentence. The court's classified TRO, the objections were not jurisdictional because habeas jurisdiction does not mean subject matter jurisdiction. Right, but it might mean other types of jurisdiction. So then the only other sources that Pisco's offered were the actual decision I read to you right here. That doesn't say, it just uses the term venue, but it doesn't say that it's only venue. Did anywhere in this? It says the detainees are confined in Texas, so venue's improper. Let's read the full sentence. For core habeas petitions, jurisdiction lies only in one district, the district of confinement. The detainees are confined in Texas, so venue is improper. Just because they use the word venue subsequently there doesn't mean that they're saying that the court's decision that they're upholding, that jurisdiction lies only in one district, the district of confinement, that it's only because of venue issues. They're merely stating the fact this venue, the location where the court Boasberg lies, is improper. It may be just a venue issue. It may be more. It may be a jurisdictional or issues beyond venue. Does anyone disagree with that? There can be venue issues, and in addition to that, jurisdictional issues. And if you say that's the improper venue, you are not necessarily saying, but it's only venue, it's not any other issues. Because venue could also, just like the word jurisdictional, as Pisco's arguing, could have multiple meanings, then it would go to fact that the word venue also could. One of the arguments for venue could be the specific term with specific types of issues that says that it's the improper location. Another could be, or it could be, I'm sorry, let me, instead of off the cuff coming up with definitions, let me use the definition that we agreed to. Venue, the proper or possible place for a lawsuit to proceed, because the place has some connection with either the events that gave rise to the lawsuit or with the plaintiff or defendant. The territory, such as the country or the political subdivision over which a trial court has jurisdiction. Right? Just like Pisco says, well, the territory, back to this example, right? Well, when it says territorial jurisdiction, one definition is, yes, your jurisdiction to rule within a territory, but the other is the actual landmass. Same here. So why couldn't it be that the venue is definition 2 here that they're citing? The territory, the court itself is the wrong venue. It's the wrong territory. In addition, even if you use definition 1, it is entirely plausible to say that it's an improper venue because of jurisdiction. Does anything in that definition of venue say, notwithstanding issues of jurisdiction? No. It just says improper place. Okay. So if I say the state of Pennsylvania is the improper place to hear a murder case that occurred in California by residents of California, is that merely a venue issue that's separate from jurisdiction? Well, no, because, and this is where it's going to get confusing, the territorial jurisdiction can sometimes be subject matter jurisdiction and sometimes be personal jurisdiction. In other words, I think that it's entirely reasonable to say you do not have access to the subject matter if you are the incorrect territory. In that case, the territorial, that's why when Pisco says some territorial jurisdiction can't be waived, some can. Right. Because territorial jurisdiction is a type of jurisdiction that falls into like other larger categories. Subject matter jurisdiction. Does the court of the United States, the federal courts of the United States, have the right to rule on civil disputes that take place completely within the nation of Spain? No, they do not have the territorial jurisdiction. Therefore, the subject matter of crimes that occur in Spain are outside of their purview. They would also lack the personal jurisdiction to compel people in Spain that aren't in the United States that are doing things that aren't any way connected to the United States. They would lack the personal jurisdiction. Therefore, it would be the improper venue. Now, one more thing before we get to the real good stuff. Notice how Pisco's premise is here It says if habeas territorial jurisdiction rule is only a venue rule, then it's not a jurisdictional rule. But if you go here, it says jurisdiction lies in only one district, the district of confinement. It doesn't say the habeas jurisdictional rule. Now, this might be nitpicky, but again, what he'll have you believe is, well, you know what? We'll dispense with this, because actually now I'm making an argument for Pisco in my head, so we'll dispense with that. So we've already gone through Boasberg, his objection. He's just talking about subject matter jurisdiction, and he's saying, oh, this is what the courts, we shouldn't listen to Boasberg anyways, because he's just recontextualizing the Supreme Court that overruled him. We've already read the Supreme Court document from the Trump case, and so now we're left with Kennedy. He then cites, scholars cite the waivability of venue as the most important difference between venue and jurisdiction. Habeas territorial jurisdiction rule can be waived, providing more support that it's a venue rule and not a jurisdictional rule. And this author says, the most important difference between venue and jurisdiction is that a party may consent to being sued in a district that otherwise would be improper venue, and it waives objection to venue if it fails to properly assert. But that's not going to help, and because you could also waive personal jurisdiction, and that doesn't mean that it's not jurisdiction. When I brought this up, Pisco just says, I'm agnostic to that. It's irrelevant. It is not irrelevant, as we'll see. At best, right now, what that does is, if he can't argue that point, then this source is irrelevant. It could be that some venue considerations be waived, others couldn't. It could be that some matters that could be waived are still jurisdictional and others aren't. And then what he's citing here is the Kennedy concurrence, because immediate custodian territorial jurisdiction rules, objections of filing the petitions based on those grounds could be waived by the government. Okay, they could be waived, but that doesn't prove that they're only venue issues. In fact, if I could prove that other types of jurisdictional orders could be waived, then this doesn't prove that it's only a venue issue. That leaves us with one source. One. Right here. Justice Kennedy writing in his concurrence for Rumsfeld v. Padilla. Now we'll get to the good stuff. Andrew Shatner was right about this early on. The problem is that and this is totally a fault of mine, I had the right argument in my head before the debate. I had it. And then through exhaustion, ignorance on my part, Mr. Ubercross, thanks so much for the $20, says, a better way to think might be A, a court can only hear a case if it has all jurisdiction. Correct. B, or 2, the government doesn't give jurisdiction unless it lets you. The government, 3, the government only lets you bring habeas where you are. Right. Habeas is unique. Even if he is correct about venue, one, he isn't correct that it's only a venue rule. Second, I think there is a debate about whether all venue rules are non-jurisdictional. I think some may be, but others may not be. But third, habeas, as everyone admits, including the authors that he has cited, is different. It is not a conventional venue type argument. It is unique. It is expressly spelled out who has the jurisdiction in the law. Now, for me, the first time really hearing terms like personal jurisdiction, subject matter jurisdiction, in my mind, it would make sense. If you asked me last week, when does a court have jurisdiction to rule? I would have said something like this. Well, when they are in the correct geographic location, when they have the correct type of court to hear those types of cases, right? And when they have the correct people. That seems to be, as a layman, the 3 issues that would make most sense to me. In other words, the more specific jargon of this would be, do they have subject matter? Yes. Do they have the right territory? Yes. Do they have the right people and the authority to have those people? Yes. Okay, then they have jurisdiction. When can a court overrule? Does the court have the authority to do so? They're above that court. That's what I would have said. Territorial jurisdiction. Once I remember reading, I was like, just real quick as I was skimming through, it's like, well, there's personal jurisdiction and there's subject matter jurisdiction. To me, I was like, oh, so territorial jurisdiction would be a subset of those two. In other words, if you look at personal jurisdiction, in order to prove personal jurisdiction, you have to prove that there is a location to the area. So again, here's jurisdiction. Jurisdiction. Power of the court to adjudicate the case. One of the most fundamental questions is given the court has jurisdiction to preside over a given case. Jurisdictional question we can break down into three components. Whether there's personal jurisdiction, whether there's subject matter jurisdiction, and whether there's jurisdiction to render the particular judgment sought. Now, arguably, this third area, because he couldn't do the class action, he didn't have that jurisdiction, right? Because it has to come down to writs of habeas with individual complainants in individual courts. The remedy sought, the jurisdiction to render the TRO, there was not a jurisdiction for. But I'll admit that's not what I was meaning. Well, I kind of said I didn't think he had the ability to send these planes home, but not for that reason necessarily. So, but I think that's an interesting point. Nonetheless, let's just look at the other two. Then you have to have subject matter jurisdiction and you have to have personal jurisdiction. What's personal jurisdiction? Personal jurisdiction refers to the power that a court has to make decisions regarding the party being sued in a case. Before a court can exercise power over a party, the U.S. Constitution requires that the party has certain minimum contacts with the forum in which the court sits. That's in Shoe v. Washington. So if the plaintiff sues a defendant, that defendant could object to the suit by arguing that the court does not have personal jurisdiction over the defendant. In other words, location. You have to have some sort of connections to the area. The courts in Pennsylvania don't have personal jurisdiction over you if the crime that you're alleged to commit or the issue that's being brought forth to the court has no connection to Pennsylvania. If you have no connection to Pennsylvania, they would not have personal jurisdiction over you. So it seems to have a significant geographic component. Waiving personal jurisdiction. Personal jurisdiction can generally be waived. Contrast this with subject matter jurisdiction, which cannot be waived. So if the party being sued appears in a court without objecting to the court's lack of personal jurisdiction, then the court will assume that the defendant is waiving any challenge to a personal jurisdiction. Now that's going to be very important. Remember, Pisco's author says the waivability of venue proves that it's not jurisdiction. And yet you could waive personal jurisdiction, which is one of the types of jurisdiction that is necessary to have complete jurisdiction to adjudicate a case. Notice also here, when talking about waiving of personal jurisdiction, doesn't this sound a lot, although it is different, doesn't it sound a lot like venue? Let me be clear. Personal jurisdiction is not the same as venue in my reading of it. But if you're held in a court that doesn't have personal jurisdiction over you, you could say that it is the wrong venue. You could file and say that it's an incorrect venue. You could also, even if the court would have jurisdiction over you, for example, you're here, but the court's here. Although it has jurisdiction, the state law says that it has jurisdiction. You could also file improper venue. See? So there are two types of improper venue challenges that you could raise. One is you don't have personal jurisdiction over me because I'm not in the geographic area nor have connections to it. And the second is, well, you do have personal jurisdiction, and yet I'm filing that it's still the inconvenient venue. Does everyone understand that? Now, this is devastating for Pisco's argument. Because what that implies is, if, in the case with these habeas petitions, there was no personal jurisdiction over the defendant, then it is clearly a jurisdictional issue that would be remedied by moving the venue. Does anyone disagree? Let's bring that up real quick. I want to bring up, because Pisco did give a definition of personal jurisdiction. So I want to bring it up just to see if there's any significant discrepancies. His definition for Black's Law says a court's power to bring a person, sorry, the font's a little low, into its adjudicative process, jurisdiction over a defendant's personal rights rather than merely property interest. Also termed in personam, jurisdiction in personam. Very similar. Personal jurisdiction, the power the court has to make decisions regarding the party being sued. Before they could do that, the U.S. Constitution requires that it has certain minimum contacts with the court. If you don't have contacts, okay, this district court is in D.C. I've not been to D.C. I don't live in D.C. The issue that we're referring to isn't in D.C. Therefore, they do not have personal jurisdiction over me. Is that also an improper venue? Yes, but it's still a jurisdictional issue. I could waive that. So saying, well, you could waive venue, therefore it must not be jurisdictional. No, what they're saying is you could waive venue, you could waive personal jurisdiction, therefore that separates it from subject matter jurisdiction. But that does not mean, because you could waive personal jurisdiction, that it's not jurisdictional. Last thing it says, obtaining personal jurisdiction. Typically, for a court to have personal jurisdiction over a defendant, the plaintiff needs to serve the defendant in the state in which the court sits, and the defendant needs to voluntarily appear in court. Federal Rules of Civil Procedure Rule describes whether the state's courts would have the authority to adjudicate a claim as it relates to personal jurisdiction. Now, remember that, the Federal Rules of Civil Procedure Rule, because in the Kennedy concurrence, not to jump the gun here, he's going to say those federal rules are superseded by the specificity of the habeas law. Now, you'll notice there that it said that there were several types of in-person jurisdiction. One is in personam. That's the one that we're going to focus on. In personam literally translates to against the person, refers to the court's power to adjudicate matters directed against a party. In personam jurisdiction is one of the two forms of personal jurisdiction, the other being in rem. A court may exercise in personam jurisdiction over a person who resides in, maintains connection with, or is served notice of legal proceedings in that court's area of territorial jurisdiction. In other words, if you are not within that district court's area of territorial jurisdiction, then they do not have personal jurisdiction over you. For example, a Delaware district court has an in personam jurisdiction over citizens of Delaware, companies which do business in Delaware, and people who are served while visiting Delaware on vacation. Additionally, a Delaware district court can exercise in personam jurisdiction over any person who consents to the exercise of it, regardless if they fall into the three categories above. You could waive your jurisdictional rights. In personam judgments allow for a wide range of judicial remedies. While we're at it, let's look up territorial jurisdiction. Territorial jurisdiction is the court's authority to preside over legal proceedings in a geographical area. Territorial jurisdiction is the scope of a federal court and state court's power and is determined by the governing laws and regulations of the area. Factors that are considered when granting a court territorial jurisdiction over the case include the cause of action that took place, where the cause of action took place, the residency of the parties involved, or the nature of the dispute. State court territorial federal court territorial jurisdictions determined by the Due Process Clause. Federal courts have territorial jurisdiction over federal questions or statutes. For example, a federal court has territorial authority over criminal cases involving a federal crime. Then it again mentions Rule 4 of the Federal Rules of Civil Procedure further clarifies territorial jurisdiction in federal courts, like the long arm statutes. Now we've set the table. Can places have jurisdiction but be the improper venue? Yes. This state of Pennsylvania has jurisdiction over, we'll just say for the sake of argument, all the stuff that happens in here, criminally or civilly. However, if I do something here, and the case is about actions that took place here and I live here, and it's held here, that could be an improper venue. However, if I'm, let's do it, in Ohio, and I live in Ohio, and the other party lives in Ohio, and some sort of action takes place, is this the proper venue? No. Is this the proper venue? No. Do they have jurisdiction, personal jurisdiction? No. They both lack the personal jurisdiction and the venue is improper. No. It's the opposite of proving that Pisco is right. Again, remember, in order for Pisco to be correct, he amended this. But in order for him to be correct, he has to prove both of his premises. The amended premises are: 1, if habeas territorial jurisdiction is only a venue rule, then it is not a jurisdictional rule. 2nd, habeas territorial jurisdiction rule is only a venue rule. He cites three sources that specifically say, forget all of this is just saying venue rules and jurisdiction is different. But it never says venue rules can't be jurisdictional rules. But even if we concede that, none of these are specific to habeas. None of these. These are just talking about venue rules in general. None of these say habeas jurisdiction rules or venue rules. None of them. So he has to prove that habeas territorial jurisdiction rule is only a venue rule. So how's he going to prove that? Support for premise 2. The habeas territorial jurisdiction rule is a venue rule because the court said so. No one's saying that they didn't say that part of it was venue. We're saying, is it only venue? He says the Supreme Court said so. We read the entire, it doesn't, nowhere in this does it say it's only a venue rule. In fact, it says for core habeas petitions, jurisdiction lies only in one district, the district of confinement. He says, but the fact that the next sentence they say the venue is improper, that proves that they think that the jurisdiction that's being referenced in the aforementioned question or sentence is only venue. That's not true. For Varel, for $5, says, wasn't JGG versus Trump just looking to remedy it under the APA and not the AA's habeas? But the Supreme Court stated the remedy was under the AA. Yes, that's correct. So that doesn't say nowhere in it. I challenge you. Does that, we'll go one by one. Does anywhere in this where he cites, does it anywhere say the habeas jurisdiction or habeas territorial jurisdiction rule is only venue? Does it say anywhere here? No, it doesn't even begin. It literally just says, we're going with the Padilla court that says jurisdiction only lies in one district, the district of confinement. We agree with the Padilla court. No, it doesn't say we agree with the concurrency. It says we agree with the opinion of the court. That's going to be important as well. Then it says the detainees are confined in Texas, so venue is improper. But venue could be improper for multiple reasons. That doesn't say it's only venue that's improper. They're not saying, yes, it occurred in an area where there was jurisdiction, but this venue's improper. It should be over here. This is saying there's only one jurisdiction. This is it. This is the only jurisdiction. And because it occurred somewhere out here, then it's incorrect. It's the incorrect venue. And it doesn't have jurisdiction. So it does not say only. The next thing he cites, the Kennedy concurrence, which we're going to read. And the last thing he cites, we already went through, is Boasberg. One, Boasberg shouldn't be preferred anyways because he's just responding to the Supreme Court that overruled him. So his interpretation that they're saying it's not jurisdictional is not to be held. And second, even in his language, he says habeas jurisdiction does not refer to subject matter jurisdiction. Right. But it doesn't say that it doesn't refer to like personal jurisdiction or territorial jurisdiction. He says it's just a question of venue. Who does he cite? Kennedy. So it seems important to read Kennedy, right? Now, here's the crux of the issue and where I screwed up, and it's the weakest part that I had in the debate. I want to show you something. And I allowed myself to be bamboozled, and it's totally my fault. Totally my fault. Here was what I wrote up beforehand. Kennedy never concludes it's a venue and not a personal jurisdiction. All of his other arguments and cites require Kennedy to have said this. Boasberg cites Kennedy. Again, all of his things, all of the authors saying venue's not jurisdiction. Venue's not jurisdiction. He has to win that, and he also has to win that this is only a venue issue. He only has, when you boil it down, only Kennedy is the only thing that he's relying on. The concurrence in the Padilla decision written by Kennedy. Kennedy must say that it's only a venue issue. That's it. Kennedy never definitively concludes it's venue and not personal jurisdiction. All of his arguments rely on Kennedy. Kennedy clearly says, even if it was venue, quote, not the proper place for this petition, as the court concludes, in the ordinary case of a single physical custody within the borders of the United States, where there's been ejection, the immediate custodian and territorial jurisdiction rules must apply. He previously said the immediate custody rule is a personal jurisdiction rule, quote, suggesting that the territorial jurisdiction rule is a venue rule and the immediate custodian rule is a personal jurisdiction rule. This approach is consistent with the reference to the respective jurisdictions. Kennedy even says specifically, he says, I'm not deciding whether or not this is personal jurisdiction or venue. That means the sole author and the sole decision that Pisco's relying on to show that the habeas territorial jurisdiction rule is only a venue rule himself says it may be personal jurisdiction or it may be venue. I'm not deciding. That's it. That's the only author he has. He doesn't ever conclude. Don't believe me? Let's go to the concurrence. Now, what happened was, Pisco's like, well, the personal jurisdiction, it just doesn't apply. It doesn't apply. Of course it does, as I'll get to why that's the case. So let's read this. Justice Kennedy, who Connor is concurring. Though I join the opinion of the court, this separate opinion is added to state my understanding of how the statute should be interpreted in light of the court's holding. The court's analysis relies on two rules. First, the habeas action must be brought against the immediate custodian. In other words, when you're bringing habeas action, the defendant in this case was listed as Donald Rumsfeld. But that's the improper defendant. There is no personal jurisdiction over Donald Rumsfeld. The warden of the prison where they're being housed is the immediate custodian. So it must be brought against them. And second, when an action is brought in the district court, it must be filed in the district court whose territorial jurisdiction includes the place where the custodian is located. These rules, however, are not jurisdictional in the sense of limitation on subject matter jurisdiction. That much is clear from the many cases which petitions have been heard on the merits despite their noncompliance. Braden, Straight versus Laird, others. In my view, the question of the proper location for habeas petition is best understood as a question of personal jurisdiction or venue. Now, I want you to see what Pisco did here, just so you can get an idea of how slippery he could be. When Pisco's citing this is what he does. These rules, see the yellow that he highlights? These rules, however, are not jurisdictional in sense of limitation. We just read that. That much is clear from the many cases. He leaves out the term personal jurisdiction. In my view, the question of proper location for habeas petition is best understood as a question of personal jurisdiction. He doesn't highlight that. He just puts venue. So Kennedy's saying, I don't know if it's personal jurisdiction or venue or what parts of it. See this? He just highlights the word venue, skips over personal jurisdiction. Laughable. We'll continue here. It's either personal jurisdiction or venue. This view is more in keeping with the opinion in Braden, and it's a discussion explaining the rules of the proper form of habeas petition. See also Moore and Olson. We might look at that as well, suggesting that territorial jurisdiction is a rule of venue rule, and the immediate custodian rule is a personal jurisdiction rule. In other words, does the law say that it has to be filed against the custodian, the primary custodian? Yes, that is a personal jurisdiction rule. This approach is consistent with the reference to the statute of respective jurisdictions of the district court. As we've noticed twice this term, the word jurisdiction is susceptible to different meanings, not all of which refer to the power of the federal courts to hear a certain class of cases. What's that sound like? The power of the federal court to hear a certain class of cases. What type of jurisdiction does that sound like to you? What type of jurisdiction does that sound like? The ability to hear a certain class of case. To me, that sounds like subject matter jurisdiction. That's what he's talking about. And this is the line that Pisco's hanging his hat on. It says, the phrase respective jurisdiction does establish a territorial restriction on the proper forum. So there is a restriction. You do not have territorial jurisdiction if you are not in the proper forum. But it does not of necessity establish the limitation goes to the power of the court to hear the case. Right, the subject matter. What's he talking about when he talks about the power of the court to hear the case? He's talking about the power of the federal court to hear a certain class of cases. Now, the reason that Kennedy's making this argument is there are specific exemptions. So there's the Braden case. In the Braden case, what happens is you have this person who files a writ of habeas in Kentucky, but he's currently incarcerated in like Alabama or some other state. And so the rules seem quite clear. If you are in Alabama, where's the proper place to file the writ of habeas? Well, it's in Alabama. That's the place where you're incarcerated. That's where you have to file. However, what the Braden case said was Braden had a retainer or a detainer to be incarcerated in Kentucky as well after his term in the prison in Alabama. And so it allowed him to place the defendant as the warden of the prison in Kentucky. So the dissent would say, see, you don't always have to file in the place of custody. Well, yes, you do. There was a special exception made because he would have been in custody in Kentucky. And so the challenge was to Kentucky. When he gets out, he will be in Kentucky in this particular prison. So that's the district where the fine. So it's still, the rule still applies. It was just an exception was made because he wasn't there then. So that doesn't necessarily establish the limitation on that Kentucky court's power to hear that case. They're able to hear that case because there was an exception. There couldn't be exceptions if it was a subject matter issue. In other words, if the courts were not allowed to hear habeas petitions, then there couldn't be an exception, i.e., there would have been a limitation on the power of the court to hear the case. That's what he means by that. He doesn't mean, it's not jurisdictional. Then he proceeds, because the immediate custodian territorial jurisdiction rules are like personal jurisdiction or venue rules. Objections to the filing petitions on those grounds can be waived by the government. Remember, we already articulated personal jurisdiction is a type of jurisdiction that's necessary to have total jurisdiction. You can waive it. You could also waive venue. The fact that he articulates that they could waive it. For the same reason, the immediate custodian and territorial rules are subject to exceptions. This does not mean that the habeas petitions are governed by venue rules and venue considerations that apply to other sorts of civil lawsuits. Although habeas actions are civil cases, they are not automatically subject to all of the federal civil rules of procedure. Now remember, when we were talking about habeas earlier and jurisdiction, it talked about the federal rules of procedure. However, what this is saying specifically here is, actually, although this doesn't operate like other sort of issues of personal jurisdiction or venue, because it's specific, it supersedes the traditional federal civil procedures. Now let's look at the law specifically. 28 U.S. Code 2241, the power to grant writ. We're going to focus on A and D. A, writs of habeas corpus may be granted by the Supreme Court or any justice thereof, the district courts, and any circuit judge within their respective jurisdictions. The order of the circuit judge shall be entered in the records of the district court of the district wherein the restraint complaint of is had. In other words, it must be in the district where you are confined. The circuit judge can only be the one in the district court of where the person is confined. Now, I want to go back real quick here. That is clearly saying, what is this saying? It is saying this is Congress writing a law that says which judge has the authority to rule on writs of habeas. Which judge could do it? The judge who is of the district court of the district where the restraint complaint of is had. Only one judge, or only judges in one district, have the ability. What's the definition of jurisdiction again? The black law definition that Pisco gave? A court's power to decide a case or issue a decree. Which court could decide this case of habeas or issue a decree? The circuit judge who is in the district court of the district wherein the restraint complaint of is had. That's it. Game over. That's it. According to the very definition that Pisco gave, the very definition, there is no jurisdiction. The only way Pisco could get out of this is to say, well, that definition isn't necessarily all-encompassing. That's it. They do not have only the district judge in the district of confinement has the ability to adjudicate or issue a decree. In fact, if you go to one of his own authors that talks about the difference between venue and jurisdiction, it says the jurisdiction of federal courts, their power to adjudicate, is a grant of authority provided to them by Congress and thus beyond the scope of litigants to confer. However, the location relates to the convenience. But this is different than tradition. Oh, I'm sorry, I wasn't sharing that, was I? The jurisdiction of federal courts, their power to adjudicate, is the grant of authority to them by Congress and thus beyond the scope of litigants to confer. Then when he talks about venue, he says, the locality of the lawsuit, the place where the judicial authority may be exercised, though defined by legislation, relates to the convenience of litigants and such subject to their disposition. The basic difference between the court's power and the litigant's convenience is historic to federal records. But again, we can see if the jurisdiction is the grant of authority granted to them by Congress, who has Congress granted the authority to weigh in on habeas? Only the district judge in the district where the person is confined. Habeas is different. Now, they also cite Section D, where an application for a writ of habeas is made by a person in custody under the judgment and sentence of a state court, of which a state which contains two or more federal judicial districts, the application may be filed in the district court for the district wherein such a person is in custody, or the district court for the district which the state court was held, with convicted and sentenced him. And each of such districts of court shall have concurrent jurisdiction. See, not venue. It's talking specifically about jurisdiction to entertain the application. The district court for the district wherein such an application is filed in the exercise of the discretion and furtherance of justice may transfer the application to the other district court. So in other words, if you're in a state that there's two federal districts, even if you're confined in one of those federal districts and you're within that state that has two, you could file either where you're being held or where the court found you guilty. Still, though, it has to be the area of confinement, or in this unique case, which doesn't apply here. That's it. Now, let's continue. Someone said, but you can't waive this. Kennedy disagrees. He says, because the immediate custodian and territorial jurisdiction rules are like personal jurisdiction, which you could waive, or venue, which you could waive, objections to the filing petitions based on those grounds can be waived by the government. But if they don't waive them, does the court have jurisdiction? I could waive my personal jurisdiction to be tried in Ohio, but if I don't, does Ohio have personal jurisdiction over me? No. This does not mean that habeas petitions are covered by venue rules and venue considerations that apply to other sort of civil lawsuits. Although habeas actions are civil cases, they're not automatically subject to all federal rules of civil procedure. Instead, these forum location rules for habeas are based on habeas statutes and cases interpreting them. Furthermore, the fact that these habeas rules are subject to exceptions does not mean that in an exceptional case, a petition may be properly filed in any of the federal district courts. When an exception rises, the courts must still take into account considerations that ordinary cases are served by the immediate custodian rule, and in similar fashion, limit the available forum to one with the most immediate connection to the named custodian. Another devastating line for Pisco here. I would not decide whether today these habeas rules function more like rules of personal jurisdiction or rules of venue. This is literally the only document that matters that Pisco has cited that could prove premise 2. He cites 3. 1, well, the word venue is used in the Supreme Court decision. Right, but that doesn't say that it's not a jurisdictional rule. 2nd, well, Boasberg says that it's not subject matter jurisdiction. Right, no one disagrees with that. And he's only citing Kennedy. And then Kennedy concludes, I'm not saying if it's personal jurisdiction or venue. Do you understand that? Again, Pisco conceded that he has to prove that it's only a venue issue. Where is his proof? Where is it? The guy that he's relying this case on says, I'm not going to decide today whether this is like rules of personal jurisdiction or rules of venue. At best, we could say 50% likelihood that it's venue and not personal jurisdiction. Then how can he make the definitive claim that it's only venue? Where is his proof? He cites another guy that says, well, it's waivable. So's personal jurisdiction. So that's going to be irrelevant. If we're trying to decide whether it's a personal jurisdiction and or a venue issue, and someone says, well, is it waivable? We'd say, well, both are waivable. That doesn't help us decide. Boasberg says, well, it's not subject matter jurisdiction. Great. Kennedy, the court that he's concurring with, none of them said it was subject matter jurisdiction. And the Supreme Court in this case, Trump versus JGG, says jurisdiction's only in one court, the court of confinement. Therefore, it's the improper venue. That's not saying it's only venue. That's it. So when Andrew said earlier, look, habeas is different. Exactly. Let's keep reading here. The concurrence. It's difficult to describe the precise nature of these restrictions on filing of habeas petitions, as an examination of the court's own opinions in this area makes clear. The precise question of how to best characterize the statutory direction respecting where the action must be filed need not be resolved with finality in this case. Here, there is no waiver by the government. There's no established exception to the immediate custodian rule, just like in the Trump case. There's no rule or action that must be brought to the district court with authority over the territory in question. And there is no need to consider some further exception to prove the integrity of the writ or the rights of the person detained. For the purposes of this case, it's enough to note that even under the most permissive interpretation that it's just venue, the Southern District of New York is not the proper place. As the court concludes, in the ordinary case of a single physical custody with the borders of the United States, where the objection has not been waived by the government, that's the case we're referring to with Trump, the immediate custodian and territorial jurisdiction rules must apply. I also agree with the arguments from statutory text and case law that the court martials in support of these two rules. Only in an exceptional case may the court deviate from these basic rules to hear a petition. So when can they hear? Right? That's going to be an important word. When does Justice Kennedy say they could hear a habeas petition? In other words, they have jurisdiction filed against someone other than their immediate custodian or prisoner. So only in an exceptional case may a court deviate from those basic rules to hear a habeas petition filed against some other person than the immediate custodian of the prisoner or some other court and the one whose territory custodian might be found. Again, let's go up. This is the line that Pisco is resting his hat on and that I actually got tricked up on. The phrase respective jurisdiction does establish a territorial restriction on the proper form for habeas petitions, but it does not of necessity establish the limitation goes to the power of the court to hear the case. And I asked Pisco, was like, well, wait a minute. Do you think the power of the court to hear the case is different than the power of the court to adjudicate the case? And he's like, no, I don't think so. I agree with him. So, aha, there it is. Then respective jurisdiction, it's not necessarily saying it's jurisdictional because it's not limiting the court's power to hear the case. But one second, if you go to the previous sentence, it says, as we've noticed twice in this term, jurisdictions means different things, not all of which refer to the federal court to hear a certain class of cases. In other words, subject matter jurisdiction. And it's clear that that's what Kennedy's referring to in the following sentence when he says that these jurisdiction rules don't go necessity to the limitation of the power to hear the case. Because later, he talks specifically about in the ordinary case of physical custody within the borders of the United States where objections not been waived, the immediate custodian and territorial jurisdiction must apply. I agree with the arguments from statutory text. to support these rules. Only in an exceptional case may a court deviate from those basic rules to hear a habeas petition. So the rules say the only time you can hear a habeas petition is if you are the court in the area of confinement or if one of these exceptional rules apply. Pisco has conceded that the ability to hear a case is synonymous with the ability to have jurisdiction or to adjudicate the case. And Kennedy admits if there are not exceptions, then the courts do not, even under the most, quote, his words, under the most permissive interpretation of habeas as venue, you still cannot hear a case. You do not have jurisdiction over a case unless there are remarkable exceptions. If you are not the district with the immediate custodian of the prisoner. Let's go through this real quick one more time. The Kennedy is the only source he has that's even trying to make a claim that when they say jurisdiction, it may mean venue. One, he concludes it could be personal district jurisdiction or venue. He says, I'm not deciding. Pisco's premise falls apart. Second, he specifically says that there are two aspects. There's the territorial jurisdiction rule, but there's also the immediate custodian rule. So when Pisco says in this, his premise, if the habeas territorial jurisdiction rule is a venue rule, then it's not a jurisdictional rule. But wait a minute, there are two rules. There's the habeas territorial jurisdiction rule, but there's also the immediate custodian rule, which now the reason that's going to be important is, although it is true that he refers to the territorial jurisdiction rule as possibly a venue rule, look what he says, Kennedy says. It's understood as a question of personal jurisdiction or venue. If we go to Braden, indicates that there are traditional venue considerations. Moore and Olson suggest territorial jurisdiction rule is a venue rule, and the immediate custodian rule is a personal jurisdiction rule. In other words, Kennedy is one saying, I'm not really sorting through whether it's personal jurisdiction or venue. Second, there are two rules. It seems one of them is a venue rule. The other is a personal jurisdiction rule. And third, except in extreme cases, the only courts with the power to hear, i.e. adjudicate, i.e. has jurisdiction over these things, is the court in the area of confinement. That's it. Let me write those down in case I talk to Pisco again. Okay. That's devastating. So the very author that he's citing, that Boasberg's saying, hey, it's not jurisdictional. Remember, that's what Boasberg says. He says, I'm citing Kennedy. It's not jurisdictional. Again, don't believe me. Here's support for premise 2. The habeas territorial jurisdiction rule is a venue rule because the Supreme Court said so. Okay, here's his 3 sources. 1, doesn't say that. It just uses the word venue after saying there's no jurisdiction. 2nd, Kennedy, we just read. 3rd, Boasberg, who says it wasn't jurisdictional. At worst, it was venue. He says the Supreme Court said it was venue, so he cites back to source 1. Indeed, regardless how the issue is framed, the court's been clear. Reference to habeas jurisdiction does not refer to your subject jurisdiction matter. No one argued the case. Territorial jurisdiction is a question of venue. Cites Kennedy. He does cite this other case that he says is similar, but that occurred before Kennedy. Then he keeps talking about subject matter jurisdiction. That's not what we're talking about. All right, I got to take a brief break. Give me a second, and we'll come back. We'll finish this. Babe, I'm almost finished. Hey, what's up, man? Okay, yep, I'll be there shortly. Gotcha. Hey, I gotta run, but I'll be in touch with you here later. All right, man. You take it easy. All right, we'll see. Bye. Now, the last thing we have to look at. Why should we prefer the Kennedy concurrence anyways? Now, I understand the reason that Pisco would say to prefer the concurrence was because it was a 5-4 decision and 2 people concurred. Without those 2, the decision in the Padilla case would have went the other way. But the current court isn't citing the concurrence. It's citing the opinion of the people on top. So why shouldn't we prefer that? Where does it quote from? Jurisdiction lies in only one district, the district of confinement. That's citing from the majority. Yeah, it's okay. You could hear my call. I knew. I didn't mind. That's citing from the majority. We don't care what the concurrence said necessarily and what the opinion of the court is. This current court. So what did the opinion say? And that was written by Rehnquist. It's a little longer. We'll try to get through it fast. Padilla is a United States citizen detained by the Department of Defense pursuant to the president's determination he's an enemy combatant who conspired with Al-Qaeda to carry out terrorist attacks in the United States. We confront 2 questions. First, did Padilla properly file his habeas petition in the Southern District of New York? And second, did the president possess authority to detain Padilla militarily? We answered the threshold question in the negative and thus do not research the second question present. So now they're only dealing with, did he file the petition correctly? Because we do not decide merits, we only briefly recount the facts. The district court issued its decision December 2002. The court held that the secretary's personal involvement in Padilla's military custody renders him a proper respondent to Padilla's habeas petition, and thus it can assert jurisdiction of the secretary under the New York's long-arm statute, notwithstanding his absence from the Southern District. On the merits, however, the court accepted the government's contention that the president has the authority to detain as many enemy combatants as possible. The Court of Appeals, Second Circuit, reversed. The court agreed with the district court that Rumsfeld is a proper respondent, reasoning that the case were habeas. You get it. Researching the merit, the Court of Appeals held that the president lacks the authority to detain Padilla militarily. The court concluded that neither the president's commander-in-chief power nor the AUMF decides. We granted the government's petition for cert to review the Court of Appeals ruling with respect to the jurisdictional merits of the issues, both of which raise important issues. The question is whether the Supreme Southern District has jurisdiction over Padilla's habeas petition breaks down into two related sub-questions. First, who is the proper respondent to that petition? And second, does the Southern District have jurisdiction over him or her? We address these questions in turn. First, the federal habeas, now understand what happened. They named Rumsfeld. So the idea was Rumsfeld, what was he, Secretary of State, right? We'll name Rumsfeld. We'll say Rumsfeld is the defendant in this writ of habeas. So is he the proper subject? And second, was it the proper jurisdiction? That's what they're looking at. Federal habeas statute straightforwardly provides the proper respondent to habeas petition is the person who has custody over the petitioner. The writ or order to show cause shall be directed to the person having custody of the person detained. The consistent use of the definite article in reference to the custodian indicates that there is generally only one proper respondent to a given prisoner's habeas petition. This custodian, moreover, is the person with the ability to produce the prisoner's body before the habeas court. We summed up the plain language of the habeas statute over 100 years ago in this way. So 100 years ago, the court ruled this. These provisions contemplate a proceeding against some person who has the immediate custody of the party detained, with the power to produce the body of such party before the court or judge, that he may be liberated if no sufficient reason is shown to the contrary. In other words, the reason that it's the warden is he's the dude that could literally bring the plaintiff physically, because he's the one who's physically detaining him. He could physically bring them to the habeas court, and then if the habeas is ruled to have been violated, they could free that person. That's why it must be the person who is doing the confining. In accord with the statutory language in the Wales immediate custodian rule, longstanding practice confirms that habeas challenges to present physical confinement, core challenges, the default rule is that the proper respondent is the warden of the facility where the prisoner is being held, not the attorney general or some other remote supervisory official. In this case, it wouldn't be Donald Trump. It would be the warden of the prison or the facility where these people that were being detained before they were deported were being held. Not Trump, not Pete Hegseth. If the Wales immediate custodian rule applies to this case, Commander Marr, the equivalent of the warden at the military brig, is the proper respondent, not Rumsfeld. It's withholding with the alleged enemy combatant detained in consolidated naval brig. The proper respondent is Commander Marr, not Rumsfeld. And then another case holding that the proper respondent is habeas actions brought by the military prisoner and the commandant of the military detention facility, not the Secretary of Navy. Provides that the commanding officer of the military correctional facility shall have custody and control of the prisoners that confine him. Neither Padilla nor the courts below, nor Justice Stevens' dissent deny the general applicability of the immediate custodian rule to habeas petitions challenging the physical custody. They argue instead that the rule is flexible and should not apply on unique facts of the case. First, Padilla notes that the substantive holding of Wales that a person recognizes his own reconnaissance is not in custody for habeas purposes was disproved. As part of this court's expanding definition of custody under the habeas, Padilla seemed to contend that the dissent agrees that because we're no longer physical detention a prerequisite to habeas relief, the immediate custodian rule no longer binds us. They disagree. The Court of Appeals view that we have relaxed the immediate custodian rule in cases involving prisoners detained in other federal criminal violations, and such a proper respondent is the person exercising the legal reality of control over the petitioner, suffers from the same logical flaws. Certainly, the statute itself makes no such distinction based on the source of the physical detention, nor does the case law support a deviation from the immediate custodian rule. Rather, the cases cited by Padilla stand for the simple proposition that the immediate physical custody rule, by its terms, does not apply when a habeas petitioner challenges something other than the physical confinement. 1 second, I want to check something real quick. Sorry. We're not going to read the whole thing. But you can see right now it's saying it's not Rumsfeld. That's what section 1 is saying. Rumsfeld's not the right guy. In Braden, for example, the Alabama prisoner filed a habeas petition in the Western District of Kentucky. He did not consent to the validity of the Alabama conviction for which he was confined, but instead challenged a detainer lodged against him in Kentucky. We talked about this case. Under Braden, then, the habeas petitioner who challenges a form of custody other than present physical confinement may name a respondent as the entity or person who exercises legal control with respect to the challenged custody. But nothing in Braden supports departing from the immediate custodian rule. To the contrary, Braden cites Wales favorably. Same reason in Strait and Laird. In Braden and Strait, the immediate custodian rule did not apply because there was no immediate physical custodian. That's not the case here. We would be the same with the Trump case. We never intimated that a habeas petitioner could name someone other than his immediate physical custodian respondent simply because the challenged physical custody did not arise out of criminal conviction, nor so can we do so here. Follows that neither of these follow the Court of Appeals conclusion that Rumsfeld is the proper respondent because he exercises legal reality of control. As we've explained, identification of the party exercising legal control only comes into play when there's no immediate physical custodian with respect to the challenged custody. In challenges of present legal confinement, we reaffirm the immediate custodian, not a supervisory official who exercises legal control, is the respondent. If legal control tests apply to physical custody challenges, a convicted prisoner would be able to name the state attorney general or anyone else as a respondent. As statutory language established, practice, and our precedent demonstrates, that is not the case. They go through endo. Padilla's argument reduces to a request for a new exception to the immediate custodian rule based on unique facts of the case. While Padilla's detention is undeniably unique, it is at bottom a simple challenge to physical custody imposed by the executive, the traditional core of the Great Writ. There is no indication that there was any attempts to manipulate. His detention is thus not unique in any way that would provide an arguable basis for departure from the immediate custodian rule. Accordingly, we hold that Commander Marr, not Secretary Rumsfeld, is Padilla's custodian and the proper respondent to his habeas petition. Now let's stop for a second. Why does this matter? If I'm Pisco or someone else, I say, well, wait a minute, this doesn't matter because that's just saying, should Trump have been named or should it have been someone else? But still, because Trump's actions were allowing this person to fly, the TRO could have applied in that unique sense, but not the writ of habeas. The problem is, though, as we'll see when we get to section 2, the territorial jurisdiction rule is intertwined inexorably with the subject, the personal subject rule. Clearly, in this case, it's saying Rumsfeld was not the correct person. Therefore, they did not have personal jurisdiction over Donald Rumsfeld because he was not the appropriate person to be signed as a defendant. Therefore, even though they have subject matter jurisdiction on the subject matter of weighing in on writs of habeas, that court does not have the jurisdiction to bring Rumsfeld before them involving this case because they do not have personal jurisdiction. Because in order to have personal jurisdiction, the connection, remember, we said with personal jurisdiction, there needs to be a connection to the court. So you had to have committed the crime in that state or in the district of that court or live in the district. There have to be at least minimal connections. There are none with Donald Rumsfeld. He's not the dude that's there confining him. So when it comes to this case, there is no personal jurisdiction for Donald Rumsfeld. Now, again, Pisco might say, but wait a minute, this court wasn't ruling that. The Supreme Court didn't rule on a matter of, was Donald Trump the right person to be signed? Well, right, but that's because the court's only briefly talking about these measures as a sort of explaining even if scenario. So what the court said, and Pisco admitted this, was that Boasberg could not use the APA, under the APA, to say, hey, you can't ship these people out. Because the APA would only apply if there wasn't another remedy. There is another remedy, therefore that remedy must be used, and that is habeas. So Boasberg's TRO is vacated. However, it goes further to say, furthermore, Boasberg would not have had jurisdiction on the writ of habeas because jurisdiction is only in the area of confinement. Therefore, Boasberg is the improper venue, which, as we said, venue can be improper for multiple reasons, including improper jurisdiction, which the previous sentence says that it was an improper jurisdiction. This is saying, well, look, in order for it to be the proper jurisdiction, it has to be the area of confinement, and there's two rules. It has to be the immediate custodian is the person that has to be named, and it has to be to have jurisdiction, it has to be in the area of the court of the area of confinement. Pisco might say, okay, but just because it ruled that Trump's administration had to bring back the planes, this wasn't specifically Boasberg ruling on a writ of habeas. So if he ruled on a writ of habeas and put the name of the jailer, would he then have jurisdiction? And the answer is no, because he wouldn't have personal jurisdiction over the name of that jailer. He does not have his district court does not have personal jurisdiction over that jailer. Right? So in this case, it's saying Donald Rumsfeld was named because he's in charge of this policy. But actually, no. Only the warden of the particular detention facility, in this point, this guy's name was Marr. He's the person. He has to be the defendant. Therefore, any court that does not have personal jurisdiction over him does not have jurisdiction. Now, this is the part where I was weak in the debate that I allowed Pisco to just hand wave away. That has nothing to do with personal jurisdiction. Of course it does. Of course, just because the court didn't say, oh, and by the way, it wouldn't have been the person. What they're doing is they're citing the case. They cite the language from this decision that I just read. They don't cite from the concurrence, they cite there. And what does it say? It says, jurisdiction lies in only one district, the district of confinement. Why? Well, because of the territorial jurisdiction and because of the personal jurisdiction. They would not have personal jurisdiction over the person that must be cited. Boasberg wouldn't have it. It would be some dude that runs a jail in Texas. Therefore, Boasberg cannot have jurisdiction. But just to make it more clear, let's move on to section 2, where now they're going to talk about the immediate custodian. So that's the person. Ask yourself this: if the immediate custodian must be the person that's in charge of the area of confinement, does Boasberg have jurisdiction over him? A guy that runs a jail in Texas? Yes or no? The planes don't matter. It would still be the person that had physical custody over them. He does not. He does not have personal jurisdiction, which is a type of jurisdiction necessary to have jurisdiction. So it is beyond the scope of just a regular venue rule. But just in case you say, no, they weren't talking about personal jurisdiction in that way. We only want to talk about the territorial jurisdiction. The first thing to say is, before I get on this, if we go back to Pisco's argument, if habeas territorial jurisdiction rule is a venue rule, then it's not a jurisdictional rule. Habeas territorial jurisdiction rule is a venue rule. Therefore, habeas territorial jurisdiction rule is not a jurisdictional rule. He added the words, we have to add the words only there. But even if we accept that, if we accept all three of those arguments, and I can't believe I missed this the other night. If all three of those arguments are true, guess what? That doesn't answer the question set forth, which was, did the Supreme Court say that he didn't have jurisdiction? That would only, he needs to add another premise, which was, it was only the territorial jurisdiction rule that the court cited. That's not true. They cited Rumsfeld versus Padilla. Rumsfeld versus Padilla expressly is saying here, there is a second sub-question having to do with the Habeas territorial jurisdiction rule, the respective jurisdictions. However, the first rule is the immediate confinement rule, which is separate from the respective jurisdictions rule. In other words, I could grant every one of Pisco's arguments and say that doesn't take into account the immediate confinement rule. Because the immediate confinement rule says that only the proper jurisdiction and venue would be if you have personal jurisdiction over the jailer, then there's no jurisdiction. But we'll further read with now to the second sub-question. District courts are limited to granting habeas relief within their respective jurisdictions. Again, Pisco's going to say that wasn't the question before them. They never said there wasn't personal jurisdiction. Well, they did by citing this case, the language of this case. And so the reasons that this court said that they agreed with jurisdiction lies only in one district, the district of confinement. They're citing this court's decision, and this court says the reason we say that's because the immediate confinement rule, which is a lack of personal jurisdiction, and this territorial jurisdiction rule. But even beyond that, even if we accept that argument, one last Hail Mary, let's see what they say here. We now turn to the second sub-question. District courts are limited in granting habeas relief within their respective jurisdictions. We have interpreted this language to require, quote, nothing more than the court issuing the writ have jurisdiction over the custodian. Let me repeat that. Nothing more than the court issuing the writ have jurisdiction over the custodian. Thus, jurisdiction over Padilla's habeas petition lies in the Southern District only if it has district over Commander Marr. We conclude it does not. That's devastating. In other words, it's saying, how do we interpret this territorial jurisdiction rule? Well, here's how we interpret it. It's quite simply a question of, do they have jurisdiction over the custodian? No? Okay, then they don't have territorial jurisdiction. They don't have jurisdiction. No, I didn't bring a lot of this up in the debate. I brought vague assertions to it, but I didn't do a good job on it. That's it. Oh, jeez. So the territorial jurisdiction, and again, the court's not citing Kennedy here. They cite the language. I can't stress enough how important this is. They're citing the language of the majority. The majority says, jurisdiction lies only in one district, the district of confinement, for two reasons. The immediate confinement rule 1, the territorial jurisdiction rule 2. Kennedy in his concurrence says, I agree. I just want to say that when it comes to the territorial jurisdiction, I'm not sure if that particular issue or these issues are issues of personal jurisdiction or issues of venue. But I'm not making that decision because I'm saying the court only has the ability to hear these cases in the district of the area of confinement. That's it. Now, why did Congress do this? Let's keep reading. Congress added the limiting clause within their respective jurisdictions to the habeas statute in 1867 to avert the inconvenient and potentially embarrassing possibility that, quote, every judge anywhere could issue a great writ on behalf of applicants far distantly removed from the courts where they sat on. Yep, exactly like what we're seeing. Literally, the court in Rumsfeld and Padilla is saying in 1867, the Congress saw that what was going to happen is you were going to have forum shopping where judges were just going to be more favorable in certain areas than others, and they would be issuing great writs on habeas for people all across the country. So Congress expressly wrote the law to say, here are the people that have jurisdiction. Only the court in the area of confinement. Again, if that's not the definition of jurisdiction, I don't know what is. This isn't a general venue rule that we're talking about, where it's like, well, we prefer that the cases happen in the venue that's closer to home, et cetera, et cetera. They expressly changed the law to say, look, we don't want forum shopping. So we will only give jurisdiction to the judge in the area of confinement. Now, there are a couple crazy exceptions, but unless those exceptions apply, then jurisdiction is only with that district court where the confinement's occurring. They continue. Accordingly, with respect to habeas petitions designed to relieve an individual from oppressive confinement, the traditional rule has always been the great writ is issuable only in the district of confinement. Other portions of the habeas statute support this common sense reading. For example, if a petitioner seeks habeas relief in the Court of Appeals or from this court or the justice thereof, the petition must state the reasons for not making the application to the district court of the district in which the applicant is held. Moreover, the Court of Appeals, this court or a justice thereof, may decline to entertain an application for writ of habeas corpus and may transfer the application to the district court having the jurisdiction to entertain it. Only one. The federal rules similarly provide that an application for writ of habeas must be made to the appropriate district court. Only one. Only one court is appropriate. That is the only court with jurisdiction. Congress has also legislated against the background of district of confinement rule by fashioning explicit exceptions to the rule in certain circumstances. Let's skip that. The plain language of the habeas statute thus confirms the general rule for core habeas petitions challenging present physical confinement. Jurisdiction lies. Again, what word do they use here? Jurisdiction lies in only one district, the district of confinement. The plain language of the habeas statute thus confirms the general rule that for core habeas petitions challenging present physical confinement, jurisdiction lies in only one district, the district of confinement. Pisco wants you to believe that, no, that doesn't mean jurisdiction. Yes, that is the exact, this is the exact language that the SCOTUS ruled. Jurisdiction lies in only one district, the district of confinement. Here's the Supreme Court decision on Trump. Jurisdiction lies in only one district, the district of confinement. They are not using the word jurisdiction here to mean geographic location. They're using it to say the court's authority to rule lies in only one district, the district of confinement. That's what everything up to this has been saying. The Kennedy concurrence, which is not cited by the current Supreme Court, doesn't dispute this. It just says it might be personal jurisdiction, it might be venue, but what it's not subject matter jurisdiction. That's all Kennedy's saying. It's not subject matter jurisdiction. But he never says it's not jurisdiction at all. He does not say that. It is clear that he is signing off on this, that's saying there's only one appropriate place with jurisdiction, the area of confinement. Despite this ample statutory and historical pedigree, Padilla contends the Court of Appeals held that the district of confinement rule no longer applies. They talk about some exceptions. We're not going to bother that. Straight case they're talking about. Straight simply had no application to the present case. Straight predated Braden. So then applicable Aaron's rule required that both the petitioner and the custodian be present in California. Thus, the only question was whether Straight's commanding officer was present in California, notwithstanding his physical absence for this district. Distinguishing Schlanger Sopra, whatever, we held that we would exalt fiction over reality to require Straight to sue his nominal custodian in Indiana when Straight had always resided in California with meaningful context in the Army there. Only under these limited circumstances did we invoke concepts of personal jurisdiction to hold that the custodian was present in California through acts of his agents. Here, by contract, Padilla seeks to challenge his present physical custody. Because the immediate custodian rule applies to such habeas challenges, the proper respondent is Marr, who's in South Carolina. There is thus no occasion to designate a nominal custodian to determine whether he or she is present. Under Braden in the district of confinement rule, we have explained Padilla must file his habeas action in South Carolina. Were we to extend Straight's limited exception to territorial nature of habeas jurisdiction to the context of physical custody challenges, we would undermine, if not negate, the purpose of Congress in amending the habeas statute. The proviso that district courts may issue the writ only within their respective jurisdictions forms an important corollary to the immediate custodian rule and challenges to present physical custody under 2241. And by the way, this language up here, this is interesting because although Kennedy does say that the government could waive, so for example, if the custodian The prison warden said, okay, I'm in this Southern District of Texas, but I'll waive it. And I'll allow the federal government says, we'll waive that. We'll allow Boasberg to do this, right? It's not even clear that they could do that. Because if the idea is that the reason that it's the person of physical custody is so that they could literally provide the body, like literally, like, I have custody of this guy. We're bringing him to this court to see if I have to let custody go. I can't waive that. I can't be like, yeah, I'll leave Donald Rumsfeld stand in for me, because Rumsfeld doesn't have the physical body. Nor could you waive the location, because the location has to be where the physical body is. But I'm not taking a stance on that. It's an interesting argument, though, that Kennedy may be wrong. The proviso that district courts may issue the writ only within their respective jurisdictions forms an important corollary to the immediate custodian rule and challenges the present physical custody. Together, they compose a simple rule that has been consistently applied to lower courts, including the context of military detentions. Whenever a habeas petitioner seeks to challenge his present physical custody within the United States, he should name his warden as the respondent and file that petition in the district of confinement. This rule, derived from the terms in the habeas statute, serves the important purpose of preventing forum shopping by habeas petitioners. Without it, a prisoner could name a high-level supervisory official and respondent and then sue the person whenever he's amenable to long-arm jurisdiction. The result would be rampant forum shopping, district courts with overlapping jurisdiction. Again, talking about jurisdiction. You would have one, imagine, this is why it's a question of jurisdiction and not just venue. Because if it's just venue, what happens if two judges rule two different ways? That's why it's a matter of jurisdiction, or you'll have overlapping jurisdiction. And the very inconvenience, express embarrassment of Congress that it sought to avoid. One other thing, footnote 7. The word jurisdiction, of course, is capable of different interpretations. We use it in the sense as used in the habeas statute, not in the sense of subject matter jurisdiction of the court. Now that's it. It's pretty definitive. There is a debatable question is whether or not, if the law says that there is we understand that venue and jurisdiction are separate. It is debatable, but I'll concede for the sake of argument that just because a venue is ruled improper doesn't mean that it was in the improper jurisdiction. I feel that that's likely the case. So, if the proper jurisdiction to hear my case is the state of Pennsylvania, they have jurisdiction. The proper venue may be District 1. So if the trial is in District 2, I could say it's improper venue to get it moved to District 1. But that doesn't mean that improper venue can't be a jurisdictional issue. If it occurs outside of this, the territorial jurisdiction, and yet it is held in venue 2, it is both the improper venue and the improper jurisdiction. So all of Pisco's argumentation, we'll go through it one more time. I keep hitting the button to end the share screen, and I don't mean to. All of Pisco's argumentation, remember, he had to amend this in our debate. If habeas territorial jurisdiction rule is only a venue rule, then it's not a jurisdictional rule. Habeas territorial jurisdiction rule is only a venue rule. Therefore, habeas territorial jurisdiction rule is not a jurisdictional rule. His support for premise 1. He cites all of these and says that they say a venue rule could never be a jurisdictional rule. That's not true. None of those say that. None of them use that terminology. They say there is a distinction between jurisdiction and between venue. Most of it, I think, is referring to subject matter jurisdiction. But it never says a venue rule can never be a jurisdictional rule. And by venue rule, right, Now he'll say, well, we're not saying that a place says improper venue, therefore it could be for jurisdictional reasons. We're saying the rule itself is a venue rule. And for the rule itself to be a venue rule is never jurisdictional. But there's two problems with that. One, none of these say that anyways. It just says that venue is separate from jurisdiction, but it doesn't say that it can't sometimes include jurisdiction. And second, that's not what the court is saying here, because he's then going to have to switch that argument here where they say the court rules jurisdiction only in one district, the district of confinement. The detainees are confined in Texas, so venue is improper. That is what they're saying there. They're not saying it's a venue rule. They're not citing anything about what type of rule it is, other than to say it's jurisdiction. Because of the lack of jurisdiction, that's the improper venue. That's what they're saying. Premise 2, habeas territorial jurisdiction rule because the Supreme Court said so. It does not. He cites three things. One, the aforementioned Trump decision, all it does is use the word venue. It does not. It says it's an improper venue. It says the reason it's improper venue is because the jurisdiction's only in one district, the district of confinement. This isn't the district of confinement, therefore improper venue. That doesn't mean, because they use the term venue, that it's not the improper jurisdiction as well. Second, he cites Boasberg. Boasberg says that it was not jurisdictional. He does use that term there, but then when he explains what he means by that, he says that it wasn't subject matter jurisdiction, which, as you can see, the Rumsfeld case admits full-heartedly. We're not saying it's subject matter jurisdiction. We're saying it's not jurisdictional for personal jurisdiction and territorial jurisdiction. He also cites the Kennedy concurrence and the Trump Supreme Court decision. So Boasberg shouldn't be preferred, for one, because he's being overruled. Secondly, it's just his interpretation. This isn't definitive. He's saying, this is what I think that the court said, that it wasn't jurisdictional. Third, he's not really saying it wasn't jurisdictional. He's saying it wasn't subject matter jurisdictional. And fourth, he's relying on the other two sources. So if the other sources don't say what he needs it to say, then his argument doesn't hold weight. And the third source is Kennedy. And the problems with Kennedy are threefold. One, he doesn't say he's deciding between personal jurisdiction and venue. He literally says, no, I'm not coming to that conclusion. That means Pisco literally does not have one source that says, yep, this is only a venue issue. Not one. He does not have one. Secondly, he talks specifically about how the immediate custodian rule is a personal jurisdiction rule. Because the immediate custodian rule is one of the two rules that necessitates why it has to be in that district. There's the territorial jurisdiction rule and the immediate custodian rule. That proves that at least half of this is an issue of personal jurisdiction, i.e., even if he's right that venue isn't jurisdictional, he's not making the argument that personal jurisdiction isn't jurisdictional. And it seems as if Kennedy's saying at least half of the rules being applied here are personally jurisdictionable. Lastly, Kennedy specifically says, except in areas of exception, the court can't hear particular cases or can't hear these cases unless it's the district of confinement. So when Pisco's relying earlier when Kennedy says, this doesn't say that we can't hear a certain class of cases. Right, you have the subject matter to hear the class of case. Pisco even says in the debate, when I say, wait a minute, when he says hear the case, does that mean adjudicate? He's like, yeah, I think it means the same thing. So when Kennedy literally says, unless these exceptions apply, a court cannot hear the case unless it's the district of confinement. That's his way of saying they cannot adjudicate, which is another way of saying they don't have jurisdiction. That's based on the very definition that Pisco gave. Furthermore, when you go into the actual decision, not the concurrence, but the decision, it's the decision that's cited by the Supreme Court, not Kennedy's concurrence. Just because Kennedy, you could say, well, wait a minute, this decision wouldn't have been applied had Kennedy not concurred in that way. Maybe so, but this court could have overruled it. When they're citing precedent, they're not necessarily citing all of the concurrences. I don't think it matters because I think Kennedy's concurrence, as I just got done argued, doesn't make the point that Pisco wants anyways. But even if you thought it did, they're not citing the concurrence. They're citing the actual court decision. The decision specifically says that the reason that only the district court has jurisdiction is because they do not have personal jurisdiction over the people involved there. The person that would need to be named as a defendant would be the warden of the prison where these people were detained, and Boasberg would not have personal jurisdiction over him. That's it. That's devastating. There's one more thing worth saying. Oh, also, lest we forget, as I start off, all of this discussion's just meta. The important part of this is the forum shopping aspect of it, which was my argument. Boasberg knew he wasn't the immediate custodian. He knew what the courts had said previously about this. The court says the reason that we do this immediate custodian thing in 1867, Congress wrote the law specifically this way because they were afraid of forum shopping. Guess what happened? Forum shopping. That's what happened with Boasberg. Pisco admits it. That's the important part of this. This is just a meta argument about the semantics. I was right that the Supreme Court said that he didn't have the authority. Boasberg didn't have the authority. And I talked about the forum shopping, which Pisco concedes that that's what this was, forum shopping. The only squabble is, was I technically correct when I said Boasberg didn't have jurisdiction? Pisco says, no, he didn't have venue. But I'm using the word jurisdiction. The broader implication is he didn't have the authority. So all of this is just semantics because Pisco wanted to take it there, but I do find these arguments interesting. I said the reason that it was important to go through this was, one, because Pisco appeals to his authority as a lawyer, and so if he's wrong to a layman, that's particularly embarrassing, which he is. And secondly, because I like these meta arguments because I've learned more, and I have learned more. The last thing to say is, I used Pisco's definitions. What's Pisco's definitions of jurisdiction? Remember, the question before us was, did the court say that he didn't have jurisdiction, Boasberg? This is the definition of jurisdiction that we used. A court's power to decide a case or issue a decree. I said, well, the court didn't have the power to decide a case. They didn't have the power to issue a decree. He doesn't have the authority because he is not in the correct jurisdiction. All of this argument about, well, jurisdiction doesn't really mean jurisdiction all the time, hinged on this word power, which I knew it would early in the debate. I said, define power. He wouldn't do it. He didn't define power until like the last 15 minutes. Now, this definition comes from Black's Law Dictionary. So then we should reasonably conclude that the words they are using here, that they are using those words in the context of what they define the words as. In other words, if they say the word power means one thing, then that's what they meant when they gave this definition of jurisdiction. That's the definition that they meant. They're not going to use a definition for a word that they themselves aren't giving as a definition. What did they define as power? Because Pisco's argument is, well, just because they didn't have the ability, or just because they were incapable to make a judgment here, to issue a decree or to hear the case, in theory they can, because the subject matter. That's what power means. That's how power is understood. So let's bring up, is Black's Law the same exact book? What their definition of power is. Sorry, it's in a different location. Power. The ability to act or not act. A person's capacity for acting in such a manner as to control someone else's response. Do they have the ability to act as Boasberg? No, he does not. Second, dominance, control, or influence over another, control over one's subordinates. Does he have the ability? No, he doesn't. Third, the legal right or authorization to act or not act. He doesn't have the right or authorization to act. A person or organization's ability to alter by act of will the rights, duties, and liabilities or other legal relations, either of that person or of another. Pisco's own definition of power shows that in his definition of jurisdiction, that they don't have jurisdiction. Boasberg did not have the ability to act, to issue the TRO. He did not have the ability to change Trump's policy, to bring the planes back. He did not. He did not have the authority to act, i.e. the power. Therefore, when we look at the definition, his own definition, I didn't force this definition on him, of power, of jurisdiction. A court's power, in other words, a court's ability to authorize or act, to change the behavior of, to decide a case, or issue a decree. Boasberg did not have that. He did not have that power. The laws of Congress are specific. Only the judge in the jurisdiction of the area of confinement has that power. That's it. End of story. Cut and dry. Now, could I have done a better job in that debate? Yes, I could have. Certainly. Through fog of just listening, going for 4 hours, listening to him ramble on and on. It's hard to get. Anytime you sort of make a point, it's like you got to walk 10 miles just to get 2 inches in an argument. What does hat mean? What does bank mean? What about fish jurisdiction? What would that mean? Always these absurd hypotheticals. I didn't do the best job. I fully admit it. I've been saying for a while, I was looking forward to doing, I don't think I did poorly. I just don't think I did up to my standards. And I was looking for a long time to have a debate like that. And it really excites me. So I'm glad that it happened. I have reached out to Pisco to see if he would like to talk about this again. My guess is he will not. But I would be happy to have him on to talk about this again. I'm more confident in my position. I could make the position more succinctly. And I think it directly goes to speak to the argumentation that he's having here. So that's it. I hope you enjoyed today. Is this the most important issue in the world or anything like that? No, it's not. But I enjoy these sort of meta conversations, and particularly on days when I'm not supposed to stream like today. I thought it would be fun to do so. So, all right, everyone. Thank you so much. I appreciate all of you. You guys are the best. So I don't know when I'll be streaming next, but it'll probably be around 7 p.m. either tomorrow night or Monday night, unless work gets really crazy, which it may. If that's the case, what can I do? So, but I think I've made the case pretty definitively. Again, I'm sure Pisco will do a stream commenting on my Cope stream. That's why I called it a Cope stream. He's welcome to do so. All of my arguments are out there. He could watch them. Pisco, if you're watching, you go ahead and watch them. You go ahead and prepare. We'll talk about it again if you want. My guess is I think that he knows he's wrong. I really do. And he almost had me this morning. I was thinking about it. I was like, well, okay, because of this. If you saw me earlier, was like, wait a minute. If this is the district and these are venues, and I could say you could have jurisdiction, but improper venue. But then the United States is the jurisdiction, and these are the venues. Wouldn't that be the same? But no, it's not. It's not at all. And I'm glad that I thought about it more and was able to reach the conclusion I did. As always, I'm always open. I will admit fully, I am a layman. People use that as an argument against me. I think it's funny. I want to debate people in their areas of expertise. You see anyone debating me on like healthcare with individuals with IDD? Probably not. I think it's fun to debate people on areas of their issue of expertise. And I think it's embarrassing for them if they're appealing to their authority as a lawyer and they're not doing so well. And I think that that's the case with Pisco. Uh, yeah, I agree. I think Senspar, you're right. That Pisco thinks that that's the best he'll be able to look. And now that I've done a little more research into it, I think he knows it won't go well with him. So I think he'll say, "No, I'm bored of that. We already talked about it 3 hours. We don't want to talk about it." And that's fine. Certainly, no one owes me anything. But I would be more than happy to have this discussion with him. And I don't think that it's defensible. I think he's wrong. And I think it'd be interesting to see it. So, all right. Thanks so much, everyone. I appreciate it. We'll talk to you all soon. As always, have a good one.